Okay, good morning, everybody. My name is Judge Kim Teresa Malika. You're in first appearance magistrate court. Today you will be informed of the charges and we're going to determine if there's probable cause. I want you to keep in mind that today is not your trial day. Do not talk about the facts of the case. Everything is being recorded. Okay, sorry. Everything is being recorded. You have the right to remain silent. You have a right to an attorney. There's a public defender, Mr. Romero, in the main jail, and then we have Mr. Reedy, who is here in the courtroom for people that are not at the main jail. If you have a private attorney, please let me know when you step up to the podium, okay? All right, we're going to call a couple cases at a turn. I believe Mr. McLawrence has a few cases. First one's going to be Beverly Teresa Smith.
She's a North Broward judge.
Okay, thank you.
Good morning, Your Honor.
Good morning, how are you?
Fine, thank you.
Okay, is there a Beverly Smith there?
She's there, Judge. I spoke with her earlier.
Is there a deputy at North Broward? Hi.
She's coming.
Thank you. Good morning, ma'am. Are you Beverly Teresa Smith?
Yes, ma'am.
Okay, ma'am. You have two capious misdemeanors. One is possession, or both of them are actually possession of drug paraphernalia. You failed to appear, I believe, at arraignment on one of them.
Okay.
Mr. McLawrence is here representing you, okay, ma'am?
Yes, ma'am.
Okay. Any objection to probable cause?
No, Judge. And I've spoken to Miss Smith. I have some concerns about her. I've represented her before, and it seems that her situation may be one where she's deteriorating. She did confide and let me know that she has a history of mental illness.
Okay.
So, Judge, of all of those things I'm taking into consideration, I was going to ask, or I'm asking the court if the court would enter an order transferring her over to Judge Wren's division and to place her on the earliest MI docket. She did confide that she wants to have services. She does receive SSI disability, so she may be a good candidate for Judge Wren to get her into some sort of program.
Well, she's actually going, do you know what docket, what division? Let me look up which one.
It's drug court, Judge. Judge Zeller.
Yeah,
Yes, that's where she's. I saw that she had a February 8th date in front of Judge Zeller in drug court, but that's not going to address her specific needs.
well, she actually has two dates. One's on 2/7 and one's on 2/8.
Okay, I didn't see the 2/7 date.
Yeah. That's, I can't read this writing. It's Z something. Let me see if I can see. Waiting for the computer to load up. Okay, so maybe we can get her. So what is it you'd like me to do? Because the bond currently is set at 500, and for the failure to appear, it's no bond as well.
Right. So, Judge, what I was asking is if you would enter an order transferring her to Judge Wren's division, and I could contact Joanne and try to see the earliest date to get her on the MI docket. And I know that the clerks in the courtroom, they're also very good about trying to get folks on the earliest MI docket as well.
Okay, so in the meantime, the bond's going to stay at 500 on one and no bond on the other.
And I did discuss that with her. She was fine with that. She knows she needs help, Judge.
Okay. All right, so let me ask you this. Do you have an order transferring it, or? Oh, I see, okay. See, this is the problem. It's not me, but I'll sign it anyway. Okay, thank you very much.
Thank you, Judge. I'll see you in court, Beverly.
Okay.
All right, the next one's going to be Amanda Michelle Dunaway.
She's a North Broward as well, Judge.
Okay.
And she has a new felony. Oh, I'm sorry, it's page 3 of the docket. Your Honor, I do have the notice to appear in her, the KPS on the 2017 possession matter.
Okay, I'm sorry, say that again, I was just looking up something.
She has a new felony possession of, well, she has a new possession of cocaine and possession of drug paraphernalia. That's 2018 cases. The case in which I would be representing her is the 2017 possession matter.
The MO case.
Yes, Judge. And I have that that paperwork because it's a KPS. I don't know if you have the paperwork. I have the
Yes, I do, I have, she has a no-show KPS.
I have the actual notice to appear.
Okay,
May I approach Judge?
I'm sorry, Madam Clerk, I didn't hear you. Oh, I see, I signed it right here. Oh, because it says relinquishing division presided over. Okay, if you. Oh, that's just my name written in. You're welcome. Okay. All right, so I'll give this back to you, Mr. McLaurin. Okay, so Miss Amanda Michelle Dunaway, you're charged with 1 count of possession of cocaine. Count 2, possession of drug paraphernalia or possess and/or use. Any objection from the defense, Mr. Reedy, as to 1 and 2?
As to count 1, no objection to probable cause, Your Honor.
Okay, what about 2?
No objection on that either.
Okay, Mr. McLaurin, there's a capias, so the court's gonna find probable cause. Okay, what is it you'd like me to do? We'll start with you, Mr. McLaurin.
Judge, I spoke to Ms. Dunaway earlier this morning, and she was requesting that the court resolve count 3, which is the municipal ordinance, for a variety of reasons. One of which is that by resolving that particular municipal ordinance, Judge, it does knock off $500 from her bond amount that she may be able to post. I'm not sure if I don't think she's able to post the $1,000 bond, but it would reduce her bond by $500. And she's not contesting the possession of marijuana at this point, Judge.
The problem is it gonna affect her cocaine charge?
It'll have a minimal influence on the cocaine charge score sheet. I think it's 0.2 points.
Yes.
I think in the trade-off of things, it's probably in Miss Dunaway's best interest if she wants to bond out, because there's not a lot of money here. I'll tell you some more details in a moment, but knocking $500 off of her bond, I think, would be her best path toward getting out of jail before this charge is
Okay, so
resolved.
why don't I make it 5 and 5 then? If she can afford 1,000, why not just make?
I don't think she can afford 1,000.
Your Honor, to advise the court, Ms. Dunaway, in the state of Florida alone, has 13 prior felony convictions, 18 prior misdemeanor convictions. Not counting count 3, she's been arrested in the state of Florida on 6 previous occasions for failures to appear. She has a conviction out of the state of Colorado as recently as last year for felony drug possession. Misdemeanor drug possession. And she has been to state prison previously in Florida.
Right, I understand that she went to state prison about 10 years ago.
Okay, so what is it that you're asking for, Mr.
Well, Judge, if you want to plead out the municipal ordinance, I mean, that's up to Ms. Dunaway. I, as her attorney on the possession of cocaine and paraphernalia charge, I wouldn't object to that. But she's not going to be able to make a $1,000 bond. She has lived here in Florida all of her life. She does have family here, including her father and her brother. She has no money. They have no money. She's been staying in the same residence for the last year. She's been working at a pool company for the last few weeks. She thinks her boss at the pool company may be able to come up with some money to bond her out. She's also asked me to call her ex-boyfriend to see if her ex-boyfriend will help her out. You know how that ex-boyfriend thing doesn't always work out too favorably. I told Miss Dunaway we'll find out how good an ex-boyfriend he is. But I don't think there's a lot of money here to bond her out. I know she's been in trouble before and she has a bit of a history, but she has been a lifelong resident here. It's a nonviolent third-degree felony. I'd ask the court to consider pretrial release on count one with a monitor.
And, Your Honor, the only thing I would advise the court, I can't be certain, this was brought to my attention by pretrial and I confirmed it. She had a June 2015 arrest for DUI in the state of Colorado, to which she was ultimately sentenced to 3 years probation and also possession of controlled substance. I frankly do not know if she's still on probation or not, but if she's going to take a plea, I just want to, note on the record that she may, from what I can tell, she may be, and if she is, this could be considered a violation of her probation.
Did you understand what the prosecutor said, Amanda?
Yes, I understand.
Okay.
Okay, so what is it that, hold on, ma'am, don't talk about the facts of your case. What is it that you're asking for, Mr.
Well,
McLawrence?
Judge,
on
in
the
light of
third
what the
count, which is
prosecutor
the
said,
municipal-
perhaps I would be asking, I'd piggyback off what Mr. Reedy mentioned to the court, which is that perhaps the court could consider pretrial release. I don't think it would be in her best interest at this moment until I find out more about this Colorado matter, for her to go ahead and resolve the municipal ordinance case.
Okay, well, this is what the court has a concern about. I have an Oakland Park address on the booking report. Then on the Capias, which was the 22nd of January, 2018, I have a Fort Myers address, and now I'm here in Colorado. So can someone let's just clarify what her address is.
It's Oakland Park.
Is it the 913 address?
Yes, sir.
Is that where you've been living for the last year?
Yes, sir.
Is that where you'd be living if you were released?
Yes, sir.
And who would she be living there with?
Her boyfriend, I believe, right?
Yes, sir.
Just note for the record, I don't believe Ms. Dunaway is a good candidate for pretrial. Even if you take all her convictions, all
What
31.
about a monitor?
Your Honor, even with the monitor, even if you take all 31 prior convictions out of the equation, she's been arrested on 6 occasions for failing to appear in court, not including today. And I'm looking at her booking. She's used an alias in the past. She's used different social security numbers in the past. Yeah.
Never used to.
All right, ma'am.
Don't say anything, Miss Dunaway.
Okay, this is what the court's gonna do. The court's gonna leave the bond on the Capias at 500. I don't need to put one on count 2, the drug paraphernalia. The court is gonna set a $500 bond on count 1 and do a GPS level 2. Okay? Thank you very much. Good luck to you.
All right, I'll make some calls for you, Amanda.
Thank you, Judge.
Your bond is $1,000.
Okay, next one, Mr. McLawrence.
We just got 2 more. Yeah.
Anthony Edward Warren.
Yes, Judge. Mr. Warren, I'm sorry.
Just count 1. Okay? Oh, sure, Madam Clerk, can I have that back, please? Thank you. Okay, which count? Okay, I have 171078 MO10A. Okay, Madam Clerk, if you could just update that on the form. Okay, next one is Anthony Edward Warren.
He's in the main jail, Judge.
The warrants here at Main, Judge.
Okay, good morning, Mr. Warren. You are charged with 1 count of resisting an officer or obstructing without violence, and count 2 is a Capias misdemeanor beverage violation. You are going to court on the beverage violation on February 8th, 2018 at 10 a.m. Anybody have an objection, Mr. McLawrence or Mr. Reedy, to probable cause in counts 1 and 2? I think one is a public defender case, the other one is Mr. McLawrence, count 2. I'm sorry, I took it out of order. Anthony Edward Warren, W-O-R-N.
Yeah, no, if he wants to resolve it, that's fine, Judge. I have no problem with that.
Okay, well, I was asking, any objection to probable cause from either of you?
No, there's no objection to probable cause.
Okay,
Not from,
All right, what would
me
you like
either,
to-
Judge.
wanna
Judge, I spoke with Mr. Warren, and, he told me that he is currently actively pursuing, job prospects, and he does believe he has a job prospect, coming up. He is homeless. And he told me he has a pregnant girlfriend. He wants to get out there so he can get that job, so he can help out with his child. And he wants to resolve this case, Judge.
okay, I don't want him to resolve it because he can't afford to get out of jail, though.
No, it's not because of not being able to afford to get out of jail, Judge. He wants to get out so he can work, so he can take care of his child.
Okay, that's fine. Oh. So you sorry about that. Okay, so state, what's your recommendation on count one?
I'm sorry, who's this, Your Honor? I
This
apologize.
is, we took this
Okay.
Warren, Anthony Edward Warren.
Your Honor, state's offer would be time served.
He wishes to accept the state's offer, Judge, on count one.
Okay, all right, what about, count two is the beverage, I'll do a adjudication and time served as well, okay? Pardon? No, I'm not up to that yet. Okay, is that what he wants to do?
Yes, Judge.
Okay, sir, raise your right hand, do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, state your first and last name.
Anthony Edward Warren.
W-O-R-N?
Correct.
Okay, you put your hand down, sir. It's my understanding you wish to waive your right to a trial in both cases?
Yes, ma'am.
Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Are you on any medications?
No, ma'am.
Do you understand that if you're not a U.S. citizen, a plea to this charge, sir, could result in deportation proceedings and affect your ability to remain in the United States?
Yes, ma'am.
Okay, understanding what I just explained to you, are you pleading guilty or no contest? In the one case to resisting without violence, and count two, the beverage violation.
No contest.
Okay, okay, the court's gonna adjudicate you on count one and, time serve you. And the court's also gonna adjudicate you in the second case, it's actually not count two, it's 17010 or 010, looks like
813.
813 MO 10A. Court's gonna adjudicate you and time serve you. On the first case, the resisting, the court is gonna impose court costs of $293. And on the second case, the beverage violation, the court is going to impose court costs, which I'm required to do, of $78. I know on the $78, we'll give them 6 months to pay. And on the $293, Mr. McLawrence, or Mr. Romero, I'm sorry, 1 year. 1 year, and I'll also, sir, give you the option of doing community service hours at the rate of $10 per hour. Okay, and Mr. Romero will explain that to you. As to the alcohol beverage violation, is that in that's in Fort Lauderdale, correct?
Yes, Judge.
Your community service would have to be in those hours, and your attorneys will explain to you how to accomplish getting credit for community service, okay? Also, you have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir.
Thank you, ma'am.
You're welcome. Cedric Lamont, Essex, E-S-S-I-X. It's also taken at a turn.
It's on page 6, Judge. He's in the main jail. He's making his way to the podium now.
Okay.
Judge, it's a municipal ordinance open container. I have the notice to appear. If the court wants to take a look at it, it's
Well,
very
he
faint.
didn't, it says he failed to appear, yeah.
Well, yes, I'm saying the original charging affidavit.
Thank you.
It's very faint, Judge.
Everything seems to be faint that we're getting. Yeah, it is. Okay, so what would you like to do with this, Mr. McLaurin?
Judge, he wants to resolve it, and he wants you to know that he didn't know about the warrant because he's homeless. He didn't receive any notice, and when he did find out, he turned himself in last night. He's
Okay,
trying
great.
he's trying to get into the homeless task force, and he needs to resolve this so he can go ahead and take care of that situation.
Okay, I don't want him resolving it just because he wants to get out. If he tells me that he's gonna appear in court next time and he can either look it up online, maybe he has a mailing address now that we can send it to. I can ROR him, or we can resolve it today of withholding court costs.
He wants to resolve it, Judge.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, your name is Cedric Lamont Essex, Essix?
Correct.
Okay, it's my understanding you wish to waive your right to a trial, sir?
Yes.
Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol or drugs?
No.
Ever been treated for a mental illness?
No.
Okay, understanding what I just explained to you, you want to plead guilty or no contest to the it's an open container?
Yes, Judge.
Okay, to the open container charge, you can put your right hand down. Want to plead no contest, sir?
No contest, yes.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court is going to withhold adjudication and impose court costs of $78. The court will give you 6 months to pay that, and also offer you the availability of doing community service hours, which you have to do. The community service has to be within the city of Fort Lauderdale from an approved list. I'll give you the community service at the rate of $10 per hour. So if you do approximately 8 hours, it'll pay your fine. You just bring the paperwork to the clerk's office. Mr. McLawrence will explain that to you further. You have 30 days to appeal the sentence of the court, sir. Good luck to you.
Thank you.
Thank you.
Thank you very much, Judge.
You're welcome.
Good morning, Your Honor.
Hello, how are you?
Okay, Steve Melnick on behalf of Amanda Miko,
North Broward.
North Broward. Miss,
Mr. McLawrence, you want this?
you.
Yes.
Can't even read this. Yes.
She's in Rhine.
Has not made it yet.
She's in Ryan, I'm sorry.
Your Honor, we'd ask you would just ROR her.
Which one is this? I'm sorry. I have
Miss
to find it.
Miko. Hi, Amanda.
Where is, what page is this? Okay, I
Page
got
2.
it. I got it. Amanda April Miko.
Yes,
Is
Your
that you,
Honor.
ma'am?
Excuse me?
Your name is Amanda Miko?
Yes, ma'am.
We'd ask you to release her ROR this.
Well, let me just ask
Thank
you
you.
first. This is an ad charge.
Yes.
Any objection to probable cause?
Not at this point in time. There is, Your Honor, because there's the actual possession issue based on the PC. But if you ROR her, it's something we can deal with in the future.
Okay.
Because Miss
Well-
Miko's due to be released in 2 days.
Okay, well, we're not there yet, so just let
Okay.
me ask you, do you have, because I don't know what I'm gonna do yet. Is there any, objection to probable cause?
Yes, there is, Your Honor. It doesn't say who had the actually had the identification on him in the probable cause affidavit.
State?
Let me,
Okay, correct.
218?
Yes.
Your Honor,
State.
for probable cause purposes, I believe an argument can be made for constructive possession between both both co-defendants, Your Honor, for probable cause purposes. Obviously, at a later date, more evidence would be necessary. And just for the court, to let the court know, should the court find probable cause, I've spoken with Mr. Melnick, I do not have an objection to ROR. in light
Okay,
of
then the court's gonna
circumstances.
find probable cause, and the court is going to ROR her.
Okay, Amanda, you call me when you get out.
Okay.
Good luck to you.
Okay, you don't
ma'am.
have to post a bond.
Thank you, Mr. Melnick. Have a
Okay,
good
thank
day.
you, Your Honor. Bye.
You're welcome. Bye-bye. Okay, Jeremy Carroll Ellis. Jeremy Carroll Ellis. Okay,
It's unfortunate.
all right. Are you Mr. Ellis?
Yes, ma'am.
Okay, Mr. Ellis, you have an out-of-state hold for a felony. It's actually an ad charge. So I guess they just became aware of it. You're gonna be held no bond, sir, pending, you being transferred out of state, okay, sir? All right. Have a good day, sir. Start, S-T-A-R-E-T, Starrett Santoni Leverson, okay? Hello, sir, are you Mr. Leverson?
Yes, ma'am.
Okay, sir, you also have an out-of-state hold felony. You're being held no bond on that charge, sir. Thank you. Okay, next one is going to be Danny Ely, E-L-Y, Ellie. She with you, Mr. Romero?
No, Judge, I've been informed he's in regular court. I don't know if confinement status has that information, because I think that's where we got it from, Judge.
Okay. All right, then we can just recall him at 1:30 or 1 o'clock.
Know if we're gonna have him back by then, Judge?
All right, well, let's just recall him. He's being held no bond. It's an out-of-state hold felony. Okay,
So
so,
maybe we should go ahead and, in abundance of caution, do it for tomorrow, Judge.
doesn't matter to me, whatever you folks request. Want to do it
It's
for
probably
tomorrow?
more efficient for tomorrow.
Okay, we'll do it tomorrow morning.
Okay?
No problem. Okay, next one is Ahmad Owens.
He's the North Broward Judge.
Okay. Ahmed Owens, please, at North Broward.
Your Honor, we didn't have him, listed here. Can you give us a minute to check to see if he is here?
Sure, he could be in regular court.
Okay, yeah, he probably is.
All right, so we'll recall it, okay? Just let us know if he comes back.
Okay.
Okay, next one is gonna be Raven Greer, Greer,
It's North Broward.
okay? Hi, are you Raven Greer?
Yes, ma'am.
Okay, ma'am, you're charged with count 1, resisting an officer, obstructing without violence. Count 2, obstruct by a disguised person, and count 3, trespass of an occupied structure or conveyance. Any objection to probable cause?
No, Your Honor. Ms. Greer indicated to me that she'd like to resolve this if possible this morning.
Okay. State?
Your Honor, after reviewing the probable cause affidavit, I do not have an offer at this time. The state's position is this case is appropriate to be transferred to Judge Lerner Wren's division.
Yeah, I see that by the comments on the first page. Okay, has she ever failed to appear or anything? She
She
have an
had-
address or
There was
says at large?
There was a resisting without violence that she got a withhold on December of last year in Dade County, and that's all I see, Your Honor.
Okay, defense?
She doesn't seem to have any kind of extensive criminal history, Judge. I'd hate to see her sitting in jail on a nonviolent misdemeanor. I understand the court's concern about some of the statements in the probable cause affidavit, but I'm not a doctor, so I don't know if she has any issues. My conversation with her this morning was pretty clear. She's from Texas. She's been a waitress for the last 2 years. She doesn't have an extensive criminal history, and she wants to resolve the case. Sending her to Judge Lerner Wren based on what?
Your Honor, I can make a record. Noting that the officer arrived at approximately 5:45 in the early evening, that from 2 in the afternoon, so for almost 4 hours, Ms. Greer was walking around Walmart, acting, it's described in an odd manner, wearing white jeans and a bra. At no time did she have a shirt on. She proceeded to a checkout lane that did not have any other customers. She remained in that lane for an extended period of time. When she was approached by an associate to ask if she needed assistance, she declined. When officers and other witnesses approached her, asked if she needed help, she began to yell. She acted erratically. She was trespassed and asked to leave 6 times. She refused to leave after each request, or after all the requests, Your Honor. My concern is, I think transfer to mental health would be appropriate. I have concern for her safety and well-being on the street at this point in time.
I just don't think that this is anywhere near enough to justify holding someone in custody with no extensive prior record, based on the opinion of one officer who is not a doctor either. This is a woman who has no mental health history that we know of. Yeah, it's an odd incident based on the perspective from the officer himself. We don't have Miss Greer's side of the story as to what happened, just an officer's opinion. And I don't think that's enough to say, hey, let's keep her in jail, let's not let her bond out, and let's send her to mental health court because we think she might have mental health problems.
Okay, does she have a, address where she gets mail or?
Ms. Greer, she's been living in the same address for, do you have an address, Ms. Greer?
Says at large. So we need a mailing address.
I have multiple addresses.
Can you give us one of them?
Which one would y'all like?
The one you get mail at.
Y'all can send it to 215 Brazos Gardens Drive.
Okay, say it slow because I'm writing it down. 215.
I'm sorry. 215 Brazos Gardens Drive.
Spell that. B.
Brazos. Brazos
Garden Drive.
Gardens with an S.
Okay.
And
What city is that in?
it's in Richmond, Texas, like Richmond, Sugarland, Texas area.
Is, okay. As long as you're gonna get your mail there. Richmond, Texas.
Yeah.
Your Honor, she's getting mail in Texas. How does that help her in Broward?
Because someone could call her on the phone. I don't know, but that's what she's given an address.
I'm
Mr. Reedy, you wanna
concerned, Your
inquire?
Honor, and that she's going to be communicating, she has no one to communicate with to get mail in Broward, so she's going to communicate with someone in Texas to get her court notices.
Okay, what's your zip code, ma'am?
It's 77469.
And is there an apartment number associated with that or a unit number?
No, ma'am. It's a house.
Okay. Whose house is it, Mr. Reedy? Just if you could briefly.
Whose house
tell.
is it, Ms. Greer?
It's my parents' house, so I usually get my mail sent over there. So
Okay,
that's cool.
that's fine. All right, this is what the court's gonna do. The court's gonna put her, ROR her on count one by putting her on standard pretrial release. The court is gonna transfer this to mental health court, and the court is gonna require, the clerk to update the defendant's address forthwith.
And Your Honor, then the state's going to object. Judge Loren has made it known that she is her intent, it's her wish that any cases that are transferred to division, the bonds be left in place, the defendants not be ROR'd. It's to ensure that they do appear in front of her. The concern being she can't be effective in her mental health court if the defendants aren't there for her to help them.
Okay. Okay. Yes, thank you.
Thank you, Judge.
Thank you, ma'am.
All right. Good luck, Ms. Greer.
Next one is Sasha St. Clair.
Miss Kim, may I, what's gonna happen? May I
You're gonna get released and you need to check into pretrial release. They'll give you a map. And make sure you keep track of your court dates.
All right, thank you.
Okay, good luck.
Thank you. Okay, Sasha St. Clair. Okay, are you Miss St. Clair?
Yes.
Okay, ma'am, you're charged with count one, grand theft auto, count two, and three are capious traffic, and those charges are expired DL, more than 6 months, you failed to appear in court, bond's been set at $500, and then you have operating without a valid license. You also failed to appear for court, and that's set at $500. Any objection to probable cause?
No, Judge, but I would say the only thing that's tying her to this stolen car is that she explained she arrived to the location in the vehicle. And she had, I guess she had the keys, but there's no indication that she actually stole the vehicle herself. And there's no indication from her that she knew that the vehicle was stolen. So I think her statement is not as inculpatory as it might first appear, which is an issue I think can be debated down the line. It might be enough for probable cause, but I think it's certainly something the court can take into consideration when setting bond in this case.
Well, she was in possession of the keys of the stolen vehicle.
Yes, that's why there's probable cause, and that's why it's still a rebuttable probable cause, because there's no indication that she actually stole the car or knew that the car was stolen.
Okay, the court is gonna find probable cause. So what are we gonna do on count one with the $1,000 bond?
Well, Judge, she's been living here in South Florida for all of her life. She has family here, including her grandmother, who she is hoping will bond her out. Unfortunately, right now, she's homeless. She's hoping that if she can get out of custody, that she would stay in a homeless shelter. I think she has a plan of where to go to stay. Unfortunately, she cannot live with her grandmother at this time. I am going to call her grandmother to see if her grandmother can come up with some money for bond. I'd ask the court to consider reducing the bond on count one, the grand theft, to $500, making it a total of $1,500. I know there's not much you can do on the capiases unless she wants to resolve them, which I'm not so sure would be a good idea.
Okay, court's not gonna do it with the pending grand theft.
Yeah, I understand that, Judge.
Okay, so, Mr. Linder, $500 bond, grand theft auto.
That's fine, Judge.
Okay, the court's gonna make the bond on the grand theft auto, $500. Ma'am, where do you get your mail? Do you get it at the 232 address?
Yes, ma'am.
Okay, and that's apartment A?
Yes, ma'am.
Okay. Let me just see the address. Okay, there's an address, 134 Northwest 10th Street. Do you get your mail there too? Because that's where the court dates went. Is that a prior address or an address where you still get mail?
I need to change it.
Okay. So your new one is the,
Second one.
okay, ma'am, so what is your address for the clerk to update?
711 Northwest 17th Street.
Any apartment number?
It's a house.
Okay, where's that, ma'am?
Pompano Beach.
Zip?
3260.
Okay, ma'am, I'm gonna have your address. So you have a total of $1,500 in bonds, okay? 5, 5, and 5. Thank you.
Your Honor,
Okay,
North Broward advises me that they have Mr. Owens from page one, the extradition case.
okay. Thank you, Mr. Reedy. Okay, are you Ahmed Owens?
Ahmad Akil Owens. Yes,
Okay.
ma'am.
Okay, good morning, Mr. Owens. You actually have an out-of-state hold for a felony, and you're being held no bond on that account. That is the warrant is from Minnesota. Okay? So you're
Yes,
gonna be held no bond, sir, and transferred to Minnesota. Good luck to you, sir.
Okay. My question, Your Honor, is how long do they have to come get me?
I believe they have 30 days. Did you go to extradition court yet?
No, this is my first appearance.
Okay, so you're gonna probably go to extradition court tomorrow, Thursday. They hold extradition court Tuesdays and Thursdays. So you either go this Thursday or next Tuesday, okay?
Okay, thank you, Your Honor.
You're welcome. Thank you.
Enjoy your day.
You too. Next one is Erin Nicole Firth.
North Broward.
Okay, good morning, Miss Firth. You're charged with one count of grand theft auto between $300 and $5,000. Any objection to probable cause?
No, Your Honor.
Okay, the court's gonna find probable cause. Ms. Firth, we have an attorney in the courtroom representing you. His name is Mr.
Okay.
Brian Reedy, okay?
Okay.
Bond is currently set at $1,000. State? What are you asking for bond, Mr. Reedy?
I'm asking for pretrial release, Your Honor. Ms. Firth has no prior criminal history. She's lived here all her life. She lives with her mother. She's been living there for the last 8 years. She had a bartending job up until last month when she lost her job. She has a 12th grade education, and I think she's a very good candidate for pretrial release based on her ties to the community, length of residence here, and lack of criminal history.
State?
That is true. She has no criminal history, Your Honor.
Okay, any objection to standard pretrial?
No.
Okay, so the court is gonna ROR her, put her on standard pretrial. Ma'am, you're not to return to the Kmart located at 3800 Oakwood Boulevard, okay?
Yes, ma'am.
All right, good luck, Aaron.
Thank you.
Next one is Maquina Montague.
Montague. Hello. How
Montague,
you
sorry.
doing? Hi.
Ma'am, you're charged with fraud or use or possess ID of another without consent. Any objection to probable cause?
It's hard enough to read, but no objection.
It is hard to read. Okay, the court is gonna find probable cause for count one. Mr. Reedy, what are you asking for?
Judge, I looked Miss Montague up on BSO Pics, and it came back that she was in the main jail. So when I was talking to Pompano, I didn't ask to speak with her. So I can't really make a recommendation without finding out some more information.
Okay,
So if you don't mind, I'll go ahead and ask her.
sure.
Okay, Miss Montague, how long have you lived in Florida?
My whole life.
And how long have you lived at the place where you live now?
I think for like 6 years.
Who do you live with?
Just me and my mom.
And do you work?
No, not right now.
When was the last time you worked?
I think that was in 2016.
Do you have any do you get any disability?
Yes, I
What-
was.
What type of disability do you get?
It was just SSI.
Okay. And would you come back to court if you were released?
Yes.
And would you be going back to live with your mom at that same location?
Thank you.
Yes.
I
I
d-
know I'll be going to my auntie.
Well, you need to know where you're going to be.
I'll stay with my auntie.
Okay. Do you know her address?
I forgot, but I know it's 26 Court in Pompano Beach.
Do you know your mom's address?
Yes.
Do you get your mail at your mom's address?
Yes, but I gotta change it. 'Cause I
Okay.
live-
But for right now, if you're released, you could use your mom's address to get mail before you change it over to your auntie's address?
Yes.
Okay. I don't know her criminal history, Judge, so maybe the state can help us with that.
She had a theft 2013, theft 2007.
It doesn't sound like an extensive criminal history, Judge. It sounds like she might be a good candidate for pretrial release.
Okay, so how are we gonna get the address where she's gonna be staying? Because I have a 246.
What's the what's the 246 address, Miss Montague?
That's my mom. That's what my mom is.
And you get mail there?
Yes.
All right, this is what the court's gonna do. The court is gonna ROR her and put her on standard pretrial. And ma'am, the court is gonna order that you have no contact, direct or indirect, with the alleged victim in this case, Abbas Khan. That means through no third party, social media, or the like. Do you understand?
Yes.
Okay,
All right.
thank you.
All right, good luck. Keep track of your court dates. Don't miss court.
Okay.
Thank you. Okay, next one is Robert Stewart Kern. These are all municipal ordinances, 10, 11, and 12.
Morning, Judge. Steve Plan here for Mr. Shate.
Hi, how are you?
How are you? Good to see you.
Good morning.
Judge, if he wants to resolve his cases, the city, he could resolve them. He has a lot of other cases. We just talked yesterday, we're in Judge Gottlieb's courtroom,
Okay,
so he could,
are you gonna, did you see that other, person that I asked?
Mrs. Rosenfeld, yes, Judge.
Yeah, from
Yes,
yesterday.
yes, Judge. She's also well known.
Okay. I
We-
think we were gonna set her for today, or you were gonna check on her. I
Yes,
just wanted to
Judge.
make sure.
Yes, your office call.
Okay, so what other charges does he have? Does he have any pending felonies? I just.
No,
wanna
no,
make
they're all,
sure he
they're all,
doesn't.
they're all the same, but the city, I mean, he could resolve these if he likes. It's time served. We still have court, because I talked to him yesterday, we still have court on February 23.
Okay, sir, you're being charged with 3 capious misdemeanors, counts 10, 11, and 12. One of them is an open container. The other one is no lodging on city-owned property, and the other one is the same thing, open container. Would you like to resolve these cases today, sir?
Yes,
Okay, raise your right hand. Do you swear and/or affirm to tell the truth?
yes,
Okay, your name is Robert Kern, Kern.
yes.
Okay, you can put your hand down. It's my understanding you wish to waive your right to a trial. Is that correct?
I'm sorry, ma'am.
It's my understanding you wish to waive your right to a trial, sir?
Correct.
Is
I
any-
think I have one on the 23rd, a trial.
Okay, well, we're talking about for these 3 ad charges today in front of me. Your attorney has indicated to me, Mr. Plant, who's covering for Mr. Shate, that you'd like to resolve the 2 open containers and the no lodging on city-owned property. Is that what you want to do, sir?
That's correct.
Okay. All right, so you want to give up your right to have a trial and plead no contest to the charge?
Yes,
Okay, this is what the court's going to do. The court is going to withhold adjudication on all 3 counts. Court is going to impose court costs of $78 on each count. Court is going to allow you the availability to do community service hours if you so desire in the Hollywood.
Yes, Your Honor.
Okay, you're going to have to do the community service in Hollywood if you so choose for the rate of $10 per hour. Okay, sir? Mr. Plan will explain to you how you get credit. All right, and the
Thank you,
court's going to
Judge.
take judicial notice of the time that you served in the Broward County Jail. Okay, sir, good luck to you. You have 30 days to appeal the sentence of the court. Thank you.
thank you very much.
You're welcome.
Have a night.
You too. Lewis Ellis.
Mr. Ellis is here at Main, Judge. Come on up, Mr. Ellis.
Okay, Mr. Ellis, you are charged with 4 capiouses. I believe they're all trespass. Am I correct?
That is what it looks like on the docket, Judge.
Okay, any objection to probable cause?
No, they're warrants.
I see, okay, for no shows.
Judge, in speaking, Mr. Ellis, he wishes to ask the court if you would consider resolving his cases today for time served.
Issue I have is it the same place that he keeps going back to?
Your Honor, the state would offer an adjudication time served. In each case, it's panhandling on I-95 off-ramp at Hillsborough Boulevard. It's not like, it's not a business or private home.
Okay. Okay, the court would adjudicate, give time served, and impose court costs in the 4 cases which I'm required to do by law.
Mr. Ellis wishes to accept the court's offer, Judge.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, Lewis Ellis, E-L-L-I-S.
Correct.
Okay, put your hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes, sir.
Is anyone
Ma'am.
forcing you to do this?
No.
Okay. All right, how do you plead to the capious misdemeanors of panhandling, sir? Trespass, other structure, actually.
What do you wish to plead, sir? Guilty or
No
no contest?
contest.
Okay, the court's going to adjudicate you, impose time served. The court is going to impose court costs of $293, which I'm required to do by law, sir, on each count. The court will give you 1 year to pay, and the court will allow you the availability of doing community service hours at the rate of $10 per hour. Mr. Romero, who's in court with you there, will explain to you how to get credit for the community service hours, okay? You have 30 days to appeal the sentence of the court, sir. Good luck to you.
Good luck, sir.
And sir, do not return to the 95, what is it, Hillsborough Boulevard, Mr. Romero?
Yes, ma'am.
Okay, no return to that location, okay, panhandling. Thank you, sir. Yes. Okay, next one is Ronald Robillard.
Mr. Robillard is here present.
Robillard,
Judge
I'm
O'Malley.
sorry.
Of course.
Mr. Robillard, you're charged with count 1, petty theft, first degree, between $100 and $300. And count 2 is possession of drug paraphernalia. Any objection to probable cause?
Based on his statements to the police, no, Your Honor.
Okay, the court's gonna find probable cause. What are we doing with this?
Mr. Robillard was actually here on the 2nd, and he was released to pretrial. He never showed up for intake, so we're asking pretrial be revoked.
Okay, did you hear that, Mr. Romero?
I did, Judge.
Okay, the court's gonna revoke his pretrial and set bond at $100. Okay,
Is that on the
Sorry?
felony case?
What's the case number? 18
Oh.
001312 CF 10A. No, $100.
Your Honor,
what's the charge on that?
we
Go
would-
ahead.
it's a,
Petty theft, second degree.
Okay,
it's a felony theft, but he was, when he was placed on pretrial, he was already out on resisting a merchant theft and 2 counts of battery.
okay, so what are you asking for as the bond?
Your Honor, there's no reason to believe that he is not going to commit a new offense when he's released. I'd ask for no bond on the felony.
Okay,
Judge, Mr. Robillard is homeless. He's 33 years old. Right now, basically, my understanding is on the case that he was out on pretrial. I believe it was some sort of grocery store in which the allegation is, I believe he took some sort of food. Now he's here at Walmart, Judge. Judge, I'd ask you at this time not to ask what the state is suggesting as far as holding him no bond.
And there definitely wasn't food in this situation. It was a bicycle, stapler, 100-piece drill set, drill and cable staples. He's also had a felony theft last year, 3 counts of theft last year.
okay,
Strong-
this is what, anything further from the defense?
Not at this time, Judge.
Okay, the court's gonna revoke his pretrial and set bond at $1,000. As to this case, the court is gonna set bond at $100. And the drug paraphernalia, I don't need to set a bond at. Okay? Sir, you have to show up for court. Mr. Romero, maybe you can explain to him how to look it up on the computer or call the clerk's office. Okay?
Can you just initial?
Sure, I'm sorry.
No. Thank you.
You're welcome. Okay, Kendrick Lee Coulter. Does anybody know where he is?
Yeah, he's in the main jail, Judge. I think he was just coming up.
Oh, okay, I didn't see him. Okay, Mr. Romero. Are you Mr. Kendrick Lee Coulter?
Yes, ma'am.
Okay, sir, you have a capious misdemeanor for operating without a valid license. Bond is set at $250. Any objection to probable cause?
It's a case, yes.
Okay,
Judge, Mr. Coulter's, right now, just finished having a conversation with him. He's wanting me to ask the court if he would consider resolving the case today.
sure. State.
One moment, Judge. State's offered be time served.
Adjudicate.
Yes.
Did you hear that, Mr. Romero?
Yes, Mr. Coulter wishes to accept the state's offer, Judge.
Okay, raise your right hand, sir. You swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, your name, put your hand down, is Kendrick Lee Coulter, Coulter.
Yes, ma'am.
My understanding you wish to waive your right to a trial in this case? Okay, is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication? Okay, you understand that if you're not a U.S. citizen, a plea to this charge can result in deportation proceedings and affect your ability, sir, to remain in the United States?
Yes, ma'am.
Okay, understanding what I just explained to you, are you pleading guilty? Oh, I'm sorry. Understanding what I just explained to you, sir, are you pleading guilty or no contest to no valid, operating without a valid license?
No contest.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file. The court is going to adjudicate you and impose court costs, which I'm required to by law, at the $293. The court is going to give you the availability of doing community service at the rate of $10 per hour if you so choose. Mr. Romero explained to you what to do if you want to do the community service, okay? You have 30 days to appeal the sentence of the court, sir. Good luck to you. Next one is Jonathan Kyle Lewis.
He's in Conte, Judge?
Okay. Okay, are you Mr. Jonathan Kyle Lewis?
Yes, ma'am.
Okay, sir, you have add charges of count 12, 13, and 14, which is burglary of an unoccupied structure, unarmed. State?
Your Honor, Mr. Lewis is being held on a burglary of a structure and possession of burglary tools. His bond on the burglary structure is $3,500. State's going to be requesting $3,500 bonds on these 3 counts. His criminal history also includes 2015 burglary of a structure, 20 months in state prison as a habitual offender. 2007, 2 counts of burglary conveyance, 2 counts of grand theft, 1 count of petty theft, 20-month state prison. 06, burglary of a structure, possession of burglary tools, 5-year state prison, possession of cocaine, 04. Dealing in stolen property, 04, 10 with the VOP, 10-year state prison. Aggravated stalking in 02, 24-month state prison, violation of injunction 02. 2 more violation of domestic violence injunctions in 2002.
Okay, defense, any objection to probable cause?
Judge, I just want to make sure I understand, because we got counts 12, 13, and 14, and we've got numerous probable cause affidavits here. Is count 12 the burglary of the New Life Community Center referred to as burglary number 1 in the probable cause affidavit?
No. Count 12 is burglary of the Greater Providence Baptist Church.
Burglary number 2.
Then count 13 is Greater Providence Baptist Church, and count 14 is Iglesia Saluz Church.
Okay. All right. The probable cause argument that I had actually was for, I guess, one of the burglaries that he's not before the court on this morning. I think there is certainly some circumstantial evidence without the DNA results of Mr. Lewis's blood, which would be much more conclusive. We don't have those results yet. Perhaps that'll shed more light on things down the road, but at this point, I would not have an objection to probable cause.
And I would also note, Your Honor, they did have the DNA results, and it was a match.
Oh, do we? I didn't see that.
Okay, 12 and 13.
Well, if it
is
was a
Greater-
match, then there's definitely probable cause.
Okay, 12 and 13 is Greater Providence Baptist Church.
Oh, here it is. Okay.
I believe,
I know you said 13 was, but,
one moment, Your Honor. It's the 3rd report,
so I'm doing a no return.
yes. No.
Can I ask,
Hold on.
I wouldn't
sir.
say anything, Mr. Lewis. You know, you've got a $4,500 bond on counts 1 and 2. I know that counts 3 through 11 have been dismissed by the state, but you still have these other 3 charges.
I just wanna know if
Well, that's something that you can fight on another day.
I'm asking if did they do it, cause I don't know.
According to the police reports, your blood was found in a DNA match on a binder that was located inside one of the burglarized churches. Whether that's true or not, I don't know. Don't discuss the facts of your case.
Okay, Mr. Linder, no return to for count 12 is where?
Greater Providence Baptist Missionary
Church?
Church, yes.
That's
Greater
for
Providence
12
Missionary
and
Baptist Church.
13?
No, that's just 12. 13 is Greater Providence, is that the same?
It's the same name.
Yeah, then it was, yes, it's the same church for those two
Okay,
counts.
so we're only putting two places, Greater Providence Baptist Church for no return, and then you said it's Iglesias something church?
Iglesia Saluz Church,
Spell the second name?
Saluz.
So really, I only have 2 charges?
You have 5 charges, Mr. Lewis. Count 1 is burglary of an, listen. Count 1 is burglary of an occupied structure. You have a $3,500 bond on that. Count 2 is possession of burglary tools. You have a $1,000 bond on that. Counts 12, 13, and 14 are burglary of an unoccupied structure. You're about to have a bond on those. So listen to what the judge has to say.
Okay, the court's gonna find probable cause on counts 12, 13, and 14, and the court is gonna order no return to the Greater Providence Baptist Church and no return to, the Iglesias Saluz, S-A-L-U-Z Church. And the court is gonna do a $3,500 bond on each count. Good luck to you, sir. Next one's gonna be Julius Joseph.
I believe he's in Paul Ryan, Your Honor.
Okay, sir, are you Mr. Julius Joseph?
Yes, ma'am.
Okay, sir, you have count 2, capious felony. It's an add charge of possession of a firearm by a convicted felon. Any objection? Well, it's capious, so,
No, it's a capious, Judge. I just asked for a reasonable bond on Mr. Joseph. He's being held no bond on count 1, which is robbery with a firearm. He has you have a status conference on the 6th, which is today?
Yes.
yeah,
He was supposed to be in court this morning.
yeah.
Your Honor, in light of the fact that he's got a no bond hold for robbery of firearm on count 1, state would be requesting a $5,000 bond.
Okay, court's gonna set the bond on the capious felony at $5,000. You're going today to serve before your division judge. Okay, I would tell them at the jail, or maybe you can call them up. He's gotta go before.
Yeah, let them know that you had a court date this morning, Mr.
At 8
Joseph.
a.m.
At 8 a.m., so maybe they can still get you to court or reset you, but we don't want a warrant issued for you, okay? So let the deputies in the jail know that you were supposed to be in court this morning,
Yes, sir.
okay? All right, good luck, man.
Okay. Darius Morton? Does anybody know where Darius Morton? Okay, thank you, Mr. Romero. Okay, Mr. Darius Morton, you have a violation of probation for a felony. You're going before your division judge FF on February 13th, 2018 at 8:30 a.m. You're gonna be held no bond until then. Okay, sir, good luck to you. Next one is going to be Michael Condon. Michael James Condon. Is he at the main jail? He is, okay.
He's here present, Judge.
Okay, are you Mr. Condon?
Yes, ma'am.
Okay, Mr. Condon, you're being charged count 1, grand theft auto. Count 2, driving while license is suspended, habitual. Any objection to probable cause?
Based on Mr. Condon's statement to the police, no.
Okay, the court's gonna find probable cause. What's your recommendation for bond state
Asking that the $1,000 bond be kept in place, Your Honor.
and the $750?
And that as well. Mr. Condon's history, 2015 grand theft, 2013 DWS habitual offender, fleeing and eluding law enforcement, leaving the scene of an accident, resisting without violence, a year and a day state prison. 2012 DWS habitual offender with a VOP, he received the same prison sentence. 08 DWS habitual offender, 34 months in state prison. 07, DWS habitual offender, VOP, 34 months. 06, possession of cannabis with intent to sell, possession of cocaine, DWS habitual offender, DUI, carrying concealed weapon, VOP, 34 months state prison. DWS habitual offender, 05, 05, dealing in stolen property, VOP, 34 months state prison. DWS habitual offender, 05, DWS habitual offender, 05, he violated probation. 03, possession of alprazolam, DUI with a breath alcohol above a .2. 04, felony possession of cannabis. 03, reckless driving with a no valid DL.
Okay, defense.
Judge, in speaking with Mr. Condon, he's been here in South Florida for 16-plus years. He's 33 years old. At this time, he did tell me he's self-employed. He does landscaping for a living. He's been doing that for several years now. Unfortunately, he says he doesn't have any money to post his monetary bond. He lives in Fort Lauderdale with his mother. He's been residing there for quite some time. Judge, he's going to be requesting if the court could release him to pretrial release.
He was also arrested about 2 weeks ago on a failure to appear in Broward.
Okay, anything further? Anything
Not from the
further?
defense. I don't know if
Okay.
the state wants to keep on talking, Judge.
Okay, all right, court's gonna set bond at $2,500 for count 1, and count 2 is gonna remain at $750. Thank you very much, sir, good luck to you. Emmanuel Johnson? Okay, Mr. Johnson,
He's here.
you're charged with count 1, violation of probation for a felony, and count 2, capious misdemeanor for petty theft. Fence?
Judge, on the violation of probation, is it an ROR or is it no bond hold?
No bond. Was signed by Judge Shear on December
Consist-
22nd,
yeah, it's a no bond hold,
2017.
Judge. Nothing to add from the defense, Judge.
Okay. Okay, so for the capious misdemeanor, the court is gonna leave the bond at 500. For the violation of probation for the felony, bond has already been set at, no bond. Sir, you're gonna be going for your felony violation of probation before Division FJ on February 12th, 2018 at 8:45. And for the capious misdemeanor charge, sir, that's gonna be set in the future, okay?
Good luck, sir.
Thank
So I
you.
still got-
Correct.
Okay, Winston Earl Moore. Then after
Mr.
that
Moore,
is
you
gonna be
approaching?
Eddie Garcia.
Come on, Mr. Moore. He's here.
Okay, Mr. Moore, you are being charged with the violation of probation for a felony. You're gonna be held no bond. You actually have a court date in Division FH on February 8th, 2018 at 9 a.m., sir. Good luck to you.
Good luck, sir. Here's Mr. Garcia, Judge.
Okay, one moment. Okay, Mr. Garcia, you're charged with 1 count of possession of cocaine. Count 2 is possession of drug paraphernalia, and count 3 is a violation of probation. You are gonna be held no bond on that charge. You are going before your division judge, which is FB, on February 8th, 2018 at 8 a.m. Any objection to probable cause in counts 1 and 2?
No, Judge, I'd ask you to leave the $1,000 bond in place in light of the no bond hold on count 3.
Okay, the court's gonna find probable cause. The court's gonna keep the bond on count 1, the possession of cocaine at 1,000. Count 2, I don't have to set a bond, and count 3, it's previously been set as no bond. Good luck to you, sir.
Good luck, sir.
February 8th is your court date. Next one is Brandon Simmons.
Mr. Simmons, come on, please.
Okay, good morning, Mr. Simmons. You're charged with count 1, grand theft auto, count 2, driving while license is suspended, second offense, and counts 3, 4, and 5 are capious felonies. You're going to be held no bond on counts 3, 4, and 5. Any objection to probable cause?
No, Your Honor, would ask the $1,000 bond be left in place in light of the no bond holds on counts 3, 4, and 5.
Okay, the court's going to leave bond on count 1, the grand theft auto with $1,000. I don't set it on the driving while license is suspended. Thank you, sir. Good luck to you. Okay? Anthony Williams.
He's here approaching Judge at Main.
Okay, Mr. Williams, you are being charged, count 1, resisting an officer or obstructing without violence, count 2, loitering or prowling, and count 3, burglary of an unoccupied conveyance unarmed. Any objection to probable cause?
Well, in the first probable cause affidavit, it seemed to me that nobody was actually identified as to who was number 1 and who was number 2, but I think that's kind of cleared up by the subsequent probable cause affidavit. So at this point, I do not have a probable cause argument.
Okay. Recommendation as to bond.
Your Honor, on the burglary, the state is going to be requesting a $10,000 bond, pretrial release with a GPS monitor. Mr. Williams is currently out on bond for burglary of a dwelling and grand theft. That alleged offense was committed less than a mile away from the alleged burglary he's before the court on.
What's that case number?
177944 CF10A. I can also advise the court, and if you'd like to see them, I could print out a copy of his DJJ report, but he also has a substantial juvenile history, including danger.
So he's out on
dangerous
bond on the
offenses.
7944 CF10A
That is correct.
for the same charge.
Well, more a burglary, yes.
Okay. Okay. Mr. Romero?
Judge, what is the date of incident on count number 3 that's here before you today?
It's actually an ad charge.
February 5th.
What's the?
February 5th.
February 5th.
Judge, at this, he's been residing in South Florida his whole life. He's 20 years old. He advised me he's advised me he works in landscaping. He's been doing that for about 2 years now. He gets paid about $75 per day. He lives in Pembroke Pines. He rents a room. He's been there for about 2 years now. His portion of the rent in renting that room in the house is $300 per month. Judge, we'd be asking you to consider setting a bond on count 3 of $2,000. And at this time, Judge, on case number 177944 CF10A, my understanding is that case is about, he's been out for 5 months. I'd actually ask you at this time to not take any action. That's not going to prevent the prosecutor in that division from filing any sort of motion if they deem it necessary, Judge. So at this time, I'd be asking you to consider setting a $2,000 bond on count 3, Judge.
State, any response as to the 17 case revoking bond?
Well, Your Honor, that would be the court's decision sua sponte. I'm not, and that's why I want to make it clear, I'm not making any kind of formal motion.
Okay. All right, let me ask you this. What is the alleged address for count 3?
It would appear to be 6405 East Osceola Circle in Hollywood. I could see 33024.
Okay, this is what the court's going to do. The court is going to set a $100 bond or keep it in place for count 1. Count 2, I don't need to set a bond. Count 3, the court is going to set it at $10,000. Sir, you're to have no contact, direct or indirect, with the person by the initials of MO. That means through social media, third parties, or the like. I'm also gonna put you on a GPS level 2. You're maintain 1,000 feet minimum from the victim's address at 6405 East Osceola Circle, Hollywood, Florida, 33024. The court, sir, is gonna revoke your bond in case number 177944 CF10A. Thank you very much, sir. Have a good day. Next one is Akito Fernando.
Your Honor, well, unfortunately, I was gonna ask that this case be reset for the afternoon. I spoke with the Detective Copley who prepared the warrant.
Sure, no problem.
We need the affidavit,
No problem.
and I won't have that till about noon.
Okay, we're gonna reset this for the afternoon today.
And Judge, Mr. Akito did decline the services of public defender. He advised me that his family did hire a private attorney, but he doesn't know the name of the private attorney, Judge.
Okay. His mother, I believe, is here. Are you his mother?
Yes, I'm his mom. Good morning.
Hello, ma'am. How are you?
I'm fine.
What is your name?
Jennifer Thomas.
Are you hiring a private counsel for your son?
Well, I supposed to go see attorney this afternoon at 1:15. So I don't know if I wasn't sure, if he was having court this morning. So
Well, we can reset this for tomorrow in the morning if you'd prefer, after you go speak to the attorney. Or your son can use the services of the public defender, just for purposes of today.
today, okay, and then the
So
next
would
time.
you, so I'm gonna ask your son, does he want, it's ultimately up to him, it's his case.
Okay.
But one of the options is we can set this for tomorrow in the morning. Did you hear Mr. Romero? The mom's gonna go speak to somebody. She has an appointment with the private attorney today at 1:15 PM. Okay,
I don't have a document.
so Mr. Fernando, your mom's gonna go speak to, a private attorney today at 1:15. We could either do your case now and you can use the services of the public defender, or we could just reset your case for tomorrow morning.
Well, I don't think we can do his case now because I think the state is requesting that the case be reset this afternoon in any event. And I have no paperwork or information on Mr. Fernando's case. It's going to be reset for this afternoon no matter what, is my understanding. Is that right, Mr. Lender?
Yes,
Or
I
we
should
could
have,
reset it for the morning.
whatever everyone.
It's fine with
wants,
me.
It's fine with me.
Okay, so this is what we can do. We can reset this for this afternoon, but the problem is that he's gonna be getting a private attorney potentially, and his mother's not gonna be talking to this attorney at 1:30, unless the mother talks to him at 1:30 and comes over after she is finished.
I'll be seeing the attorney at 1:15 today, so I'm not.
All right, this is what we're gonna do. We're gonna reset this for the PM. Okay, and then ma'am, you can come over after you're finished with the attorney. Maybe you can call the attorney up and get in earlier, okay?
Okay.
All right,
All right, thank you.
thank you. We'll reset for the PM today.
So 1:30 today?
Yes.
All right,
Okay, the
thanks.
court's gonna take a brief recess. waiting for Mr. Linder.
I think he just stepped out for just one moment.
Yeah, he did. We are gonna call Jeffrey Finley next,
Mr. Finley, come on up, please.
and then after that is Christopher Cecil Taylor.
Judge, Mr. Finley is here. He declined the services of public defender.
Okay, all right, Mr. Finley, thank you. Mr. Finley, you have a violation of community control. Your judge in Division FJ filed a warrant for your arrest and set it at no bond. You're gonna be going to court on February 12th, 2018 at 8:45 a.m., sir, okay? That's your only, matter. You don't have any new pending matters. Good luck to you, sir, okay? Next one's gonna be Christopher Cecil Taylor.
And we'll wait for Mr. Reed to come back.
Sure. Then after that is gonna be Dwight Terrell McCon. Christopher Cecil Taylor, the person before him, actually declined the services of the public defender, and I did that one. We're up to Christopher Cecil Taylor. All right. Mr. Taylor, you're here on a charge of driving while license is suspended, habitual. Count 2 is a civil traffic infraction of avoid a traffic device. Any objection to probable cause?
No, Your Honor.
Okay, court finds probable cause. Any reason I should change the bond of $750, Mr. Romero?
Judge, Mr. Taylor is 64 years old. He's been residing here his whole entire life. He lives in Hallandale with his sister. Judge, he's asking me to ask the court if you would consider straight ROR, not pretrial, but a straight ROR, Judge.
Okay. State, any objection to me doing straight ROR, no standard pretrial on driving while license is suspended?
I'm sorry, Your Honor.
No, that's okay. I understand.
Your Honor, he does have a history, DWLS's, he's had a few
Does he
failures
fail to appear?
He's had a few failures to appear in the past. Most recent, from what I can tell, though, was over 10 years ago, so I'll leave in the court's discretion however you wish to proceed.
Okay, the court's gonna ROR him. Is his address, mailing address, Mr. Romero, still 621 Northwest 10th Street?
Yes, he's shaking his head in the affirmative, indicating yes, Judge.
Okay, then we'll ROR him. Good luck to you, sir. Make sure you keep looking for your court date, okay?
Thank you, Judge.
You're welcome. Next one's gonna be Dwight Terrell McCon, and
He's approaching, Judge.
and then after that is gonna be
careful.
Jacob Perry.
Be careful, sir. Hold to the podium so you don't fall.
Okay. All right, sir, how you doing?
I'm doing fine, and you, ma'am?
Okay, fine, thank you. You're being charged, Mr. McCon, with count 1, grand theft of a firearm, count 2, possession of weapon or ammo by a convicted felon, and count 3, 4, 5, and 6 are violations of probation. I can tell you your division judge in Division FF signed a warrant for you to be held no bond on counts 3, 4, 5, and 6. And you're gonna be going before your division judge on February 13th, sir, at 8:30 a.m. What are we doing with counts 1 and 2, State?
Judge, I just asked for a reasonable bond on count 2. He's got the no bond holds. There's no probable cause argument.
Okay, court finds probable cause.
And we'd also be asking you to sign a photo order allowing us to photograph his injury, Judge.
Okay, granted as to the photo order.
All right. Your Honor, state would be, in light of the offenses he's on probation for, just looking at them, state would be requesting a $5,000 bond on count 2.
Count what?
2, I'm sorry. Count 1, I'm fine with the 1,000. with the
Okay, so the
5,000.
court is going to leave the bond at $1,000, and on count 2, the court is gonna set the bond at $5,000. Good luck to you, sir. Next one, Jacob Perry.
Mr. Perry, come on up, please.
Okay,
Judge, Mr. Perry declined services as public defender.
okay.
Had a lawyer.
Do you have
I
a,
had a lawyer,
you do? Who's your private attorney, sir?
William Moore.
Is that the, I'm just checking to see. I think you might mean that was his lawyer on the cases that he got sentenced to probation.
Talk a little louder, because he probably can't hear you.
Let me just- Yes, he was, Mr. Perry was represented by Mr. Moore on the two cases that he was placed on probation. I don't know that he's been retained, but
Okay, sir, you're being charged with count 1, distributor, deliver methamphetamine. Count 2, possession with intent to sell, manufacture or deliver methamphetamines. Count 3, drug paraphernalia, possess or use. And count 4 is just an improper change of lanes. Count 5 and 6 is a probation violation, which you are going to be going before your division judge on February 8th, 2018 at 8:30 a.m. Those are the two cases that Mr. Mora has in a notice of appearance. However, I don't know if he's going to be representing you on the violations of probation. Did he do a notice of appearance for the VOPs?
no, he wouldn't have, Your Honor, because these just came into effect based on this new arrest.
Okay, all right. All right, so in any event, sir, your division judge in Division FC has signed an order on counts 5 and 6 that you be held no bond. However, on counts 1 through 4, I have to, or actually 3, I have to set bond. But are you going to be hiring Mr. Moore for those charges?
Yeah.
Okay. Do we want to, let's do this, sir. We're going to reset you for this afternoon. Can someone call Mr. Moore and ask him if he's going to be representing this gentleman?
If you want to put it on recall, I could give him a call right now and see if, I mean, we might not
Sure,
necessarily
I'd rather
to.
have him come over. If he
Okay,
can come
well-
over for the PM.
No, I'm not saying have him come right now. What I'm saying is if I reach him now and he says, for instance, well, I haven't been retained, I'm not going to be representing him, then we,
Okay, so we'll recall. All right, sir, take a seat. We're going to call Mr. Moore for you, okay? Sorry, I didn't understand what you were saying.
it's okay.
Keeson Bishop.
Mr. Bishop is here present, Judge of Maine.
Okay, and then after that is going to be Donald William Rosh. Mr. Bishop, you're charged with count 1, possession of MDMA, ecstasy. Count 2, possession of cannabis, 20 grams or less. Count 3, possession of drug paraphernalia. Any objection to probable cause?
No, Your Honor.
Okay, the court's going to find probable cause. Bond is set for count 1 at $1,000. The other two, it's no bonds attached to it. So, what's your recommendation, Mr. Romero?
Judge, he advised me his parents are going to be posting his bond.
Okay, then we'll leave the bond at $1,000 then. Good luck to you, sir.
Thank you, ma'am.
You're welcome. Donald Rauch, R-A-U-C-H. And then after that is going to be a Joseph Peasy. Okay, are you Mr. Donald Rauch?
Yes, ma'am.
Okay, sir, you're charged with driving while license is suspended and violation of probation for a felony. Any objection to probable cause?
No, Your Honor, we'd just ask for a reasonable bond on count 1 in light of the no bond hold on count 3.
Okay, sir, you're going before your division judge, FB as in boy, for your violation of probation. Your division judge has set a no bond hold on your case. You're going to be going February 8th, 2018 at 8:30 a.m. As to count 1, the court will keep the bond at $750, okay?
Your Honor, will that be in front of Judge Rothschild?
If he's division FB, is Judge Rothschild? Okay, yes, sir.
Your Honor, we can reset Mr. Perry's case for the afternoon. I just got Mr. Moore's voicemail and left him a message letting him know what's
Okay,
going on.
we're going to recall Jacob Langdon Perry.
Mr. Perry? Judge is going to inform him.
Okay, Mr. Perry, we're going to reset you for the PM docket today. Okay? A message was left for Mr. Moore. All right, and we'll deal with it then. Thank you. Joseph Paese, and then next one's going to be Jonathan Torres. Are you Mr. Paese? Am I saying that right? Pies, I'm sorry, sir. Okay, sir, you're charged with 1 count of burglary of an occupied dwelling unarmed. Count 2, probation violation. Count 3, leaving the scene of a crash involving damage. Count 4 is flee or attempt to elude a law enforcement officer. Count 5 is driving while license is suspended, the first offense. And count 6 is resisting an officer or obstructing without violence. Any objection to probable cause, Mr. Reedy?
No, Your Honor, would ask for a reasonable bond in light of the no bond hold on count 2.
Okay. All right, the court is going to find probable cause. State?
Your Honor, in light of the fact that Mr. Pease is on probation out of Dade County for burglary of an occupied dwelling and stands before the court today accused of burglarizing another person's home in Broward, and it appears he's a Miami resident, the state would be seeking a $15,000 bond on count 1. Oh, I'm sorry, also noting that the home was occupied at the time of the alleged burglary. $15,000 bond, Your Honor, and an order of no victim contact. And actually, Your Honor, the state would also be requesting a GPS monitor. He can, if he gets brought down to Dade, they can bring him back if the case is resolved there to Broward, and the GPS monitor could be affixed before he's released from Broward County custody at that point.
Okay, this is what the court's going to do. As to count 1, the court is going to set bond at $25,000. The court is going to, he's going to be held no bond on count 2. Count 3, 4, 5, and 6, I don't need to set a bond on. I'm sorry. Count 4 is $1,000. Sir, you're to have no contact, direct or indirect, with the victim in this case. You're to maintain 1,000 feet from the alleged victim's residence in this case. And the court is going to put you on a GPS monitor, too. Good luck to you, sir. Yes. Case number 4, where? Okay, I have 15. It's so hard to read. 2156 CF10A. You can take the CF10A off. Okay.
Judge,
Yes.
in reference to count 2, the case number that you just stated is 152156 CF10A.
See, it's not CF10A because it's a Miami-Dade case. It's just 152156.
Judge, would you consider, you set a bond of $25,000 on count 1 with level 2 pretrial. Even if he posts up on, as the state said, he's going to be taken to Dade County. He's going to be held no bond on the probation case until somehow that issue is resolved. Potentially, if his probation is going to be reinstated, he's going to be on supervision there. Judge, I mean, I ask you to consider reducing the bond on count 1, considering you've placed him on level 2 pretrial. So he's going to do level 2 pretrial plus be probation on Dade County and have to post a monetary bond.
Yes, he, there's an allegation that he burglarized a home. Thank you, sir. Okay, next one's going to be Jonathan Torres.
Okay.
Is there a Mr.
Jonathan Torres, I've been informed you bonded.
Okay. Thank you. Then next one's going to be Henry Jose Gonzalez.
All right, Jonathan Baroa as the next case.
Jonathan Baroa.
Okay, I don't know why, but I'll take Jonathan Baroa then. No problem.
Thank you.
Okay, Jonathan Baroa.
He's here, me.
Okay. You are charged with 1 count of probation violation. You have a no bond hold according to your division judge. You're going before Division FG on February 12th, 2018, sir, at 8:30 a.m. You do have count 2, loitering and prowling. State?
Judge, I just ask you to leave the $25 bond in place in light of the no bond hold.
Yeah, Your Honor, I'm fine with that. I frankly, just for the record, based on the allegations, I think a more serious charge could have been placed on him, but I'll leave that up to a case filer to make that determination.
Okay, this is what the court's going to do. The court's going to leave the $25 bond. However, the court is going to do, and this is as to count 2, GPS monitor, level 2, minimum of 1,000 feet from the alleged victim's residence in this case, and no victim contact, direct or indirect. Okay, thank you very much, sir. Sorry, my pen ran out of ink, Madam Clerk.
Happens.
I know.
It's your pleasure, Judge.
Okay, are you Mr. Henry Gonzalez?
Judge, we waive formal reading of the nature of the allegations.
Okay. All right, sir, you have 8 counts, state.
It's more than that, Judge.
Oh,
Yeah,
you're
there's
right.
probably a second page
Counts.
you're finding.
You have 12 counts, sir. Your attorney has indicated that you waive formal reading of or announcement of the charges 1 through 12. State, any priors are pending?
No priors, Your Honor. On count 1, though, Your Honor, that is, I believe it's a punishable by life offense. The state is going to be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only under Isaza v. State, Your Honor. Without going into great detail because of the nature of the offenses, Your Honor, the state's relying upon the affidavit, specifically the allegations made by the alleged victim, Your Honor, content of the controlled phone call conversations and evidence that appears to have been recovered in the form of text messages and images that was sent via cellular phone.
Okay, so any objection to probable cause?
Not to probable cause, but we do have an objection as to the court making a finding of proof evident presumption great. That is the highest legal standard that we have in our criminal justice system. It's higher even more than proof beyond a reasonable doubt. In asking the court to make this high finding and also hold Mr. Gonzalez on the most restrictive means of pretrial detention, what the state has presented is nothing more than a probable cause affidavit. A probable cause affidavit is designed to do one thing, and that is to establish probable cause. It's not designed to establish proof evident presumption great. This is an allegation made by a victim that has not testified before this court. This court has had no opportunity to gauge the reliability or ability of this witness to tell the truth. The state has not presented any of these alleged statements made by Mr. Gonzalez. They have not provided the court with a transcript of the controlled phone call. They have not provided the court with any text messages that may or may not exist. All they've done is rely on a probable cause affidavit, which we would submit to this court is insufficient to reach that very high standard. We would ask the court to set bond for Mr. Gonzalez in this particular case.
Okay. So that's to count 1 only, correct? The proof
Yes, Your
evident
Honor.
presumption great. What about bond for 2 through 12? I know there's 1,000 on 11,
Yes.
12,
And-
and 7.
And, Your Honor, I'm only going to be making, frankly, in light of the totality of the bond I'm going to be seeking, I'm only going to be making recommendations for the hold for magistrate counts after count number 1. Your Honor, I'm going to be requesting bonds in the amount of $20,000 on 2, 3, 4, 5, 6, 8, 9, and 10. And, Your Honor, I may request obviously no victim contact. I may request other release conditions. But that is, I would also ask that he not be in possession of any devices with internet access. Any additional conditions I may request, Your Honor, frankly, if I may reserve argument until the court makes a ruling on the state's request on count 1.
Okay, Mr. Gonzalez, I have reviewed the probable cause affidavit filed in your
Judge,
case.
if I could,
Sure.
if I could be heard in reference to the bonds amount on the remaining counts.
Your Honor, I would ask if the court can make a ruling as far as proof evident or presumption grade first.
Yeah, let me do count 1 first, Mr. Romero, unless
Judge, are you allowed the state to go ahead and get into the remaining counts? It's only fair now you allow the defense.
Okay.
Or the decision should probably have been made on count 1.
And, Your Honor, if I may, if Mr.
Okay, did I allow Mr. Reedy, did you give an argument, Mr. Reedy?
On count 1.
Yes, I did give an argument on
He
count 1.
did give an argument on count 1, Mr. Romero, but hold on, Mr. Linder.
Yes.
Let me let them give an argument, okay? Go ahead.
As to the bond amounts, not on 1, but in reference to counts 2, 3, 4, 5, 6, 8, 9, and 10. Judge, respectfully, we'd be asking you to consider setting a $5,000 bond on each count. Mr. Gonzalez lives in Pembroke
Your Honor,
Pines.
and I have to be able to,
He's been living there for
I have to make an
3
objection.
years.
I have no objection to Mr. Romero at this point in time making the bond recommendation amounts. What I would object to, and all I made was a recommendation as to bond amounts. What I would object to is before the court makes a ruling as to proof evident presumption great, that Mr. Romero provides information as far as ties to the community, things of that nature, because that could create a bias to not finding proof evident presumption great, which should be based solely on the allegations in the report.
Okay, this is what the court's gonna do. As to count 1, I've reviewed the probable cause affidavit, sir, filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, on count 1, you're gonna be held without bond until further order of the court. This order is without prejudice for you to file a motion to set bond with the assigned division judge and request a hearing, sir, under State v. Arthur. Okay, State?
Now I have no objection to Mr. Romero providing whatever information he wants to with regard to the remaining counts as to bond.
Okay, Mr. Romero, go ahead.
Because
Yeah.
now it doesn't matter.
Judge, as I was saying before, Judge, he lives in Pembroke Pines. He's been living there for about 3 years. He lives there with his wife and kids. His mortgage is about $1,850 a month. He works for Panera Bread, Judge. His wife works at Bank of America. Financially, as far as from what the state was already, which they did recommend, that's something that they're not going to be able to come up with, Judge. That's why I'm asking for $5,000. I do understand the nature of the offense. He is being held no bond on count 1. Judge, this is his first contact with the criminal justice system, and that's why the defense is making the request for $5,000 each count.
Okay, all right, this is what the court's gonna do on counts 2, 3, 4, 5, 6, 8, 9, and 10. The court is gonna set bond at $25,000 per count. The court also is gonna require no contact, direct or indirect, with the alleged victim in this case, with the initials MR. The court is also, if he does bond out on counts, I'll do it on count 2 and 3, gonna put him on GPS level 1. Count 3 is no contact with minors, and count 4 is no possession of devices with internet. Anything else, State?
Yes, Your Honor, I would just ask, and I'm not trying to obfuscate, but if the court is inclined to do, should he post his bond at some point in time and be eligible for release, GPS, level 1, I'd ask that it be on the remaining counts, only because, for instance, we may
So you want 2 through 12?
Yes, only because, if, for instance, if we merged counts 2 and 3 into another count, then they wouldn't exist
Okay,
anymore.
then the court will put him on GPS level 2, level 1 through counts level 2 through 12.
And I apologize, the court, did the court issue an order with regards to devices with internet access?
No possession of devices with internet
Thank you, Your Honor.
access. I'll add the word access for you.
Thank you.
Okay, anything further from anybody else?
And Your Honor, I apologize, this is the last thing. Your Honor, based on the comment that was, the alleged comment that was made to the alleged victim regarding a friend, I would ask that there also be an additional condition that he not have any contact with any minors under the age of 16.
I said no contact with minors is number 3.
Then I missed it, I apologize, Your Honor.
Okay, so then I'll put under 16 years of age.
Thank you.
No contact with minors under 16?
Yes, no contact, direct or indirect, with the victim with the initials MR. Number 2 is GPS level 1 for counts 2 through 12. Yes, count 4 is no possession of devices with internet access.
And I apologize, Your Honor, what I really meant, I meant 16 and under, not under 16.
Okay, minors 16 years of age and younger.
Thank you.
Okay, and if I didn't say it counts, 7, 11, and 12 are $1,000 each, okay? Thank you very much. Good luck to you, sir. Mohammed Shihade.
Mr. Shihade?
He's taking a nap.
He's here, present, Judge.
Okay, good morning, Mr. Shahadi. You're charged with count 1, possession of heroin. Count 2, DUI, alcohol or drugs, first offense. Count 3, DUI with damage to property or person of another. And count 4 is refusal to submit to a DUI test. And count 5 is careless driving. Any objection to probable cause?
No, Your Honor.
Okay, the court finds probable cause. Recommendations as to bond.
Your Honor, I'm going to. Okay, Your Honor, I'm okay with the bond amounts, but with those bond amounts, I would be asking for shitty bond pretrial release with a TAD monitor. This does appear to have been a serious accident, Your Honor. I know it stated that I believe it was Mr. Shahade's car almost flipped over as a result of the crash. I note he does have a prior refusal on his record. He's also, and I would be asking the court to issue a no alcohol or intoxicants. He does have priors for not following court orders in the past. 2014 in Palm Beach, violation of injunction. 2014 Palm Beach, violation of injunction. It looks like he pled the DUI out in 2011 to reckless driving. And Your Honor, I would just note as far as financial resources, it does believe, one moment. Mr. Shihade was driving a 2017 Toyota.
Okay, defense?
Judge, I believe the vehicle that he was driving was a rental car. It's not Mr. Shihade's. Judge, in speaking with Mr. Shihade, he does have family that live in our community, specifically his uncle that he was going to be trying to contact to post his monetary bond. He doesn't know if he's going to be able to come up with that full amount. He is worked for Cricket Wireless, but now he believes since he didn't show up today, he probably lost his job. He was only making about $10 an hour. He's lived here his whole entire life. He lives in Coconut Creek. Judge, at this time, I'd ask you to either keep the standard bonds in place of the $2,500 bond, or in the contrary, ROR him and place him on pretrial release.
Your Honor, if I could have, Mackenzie, you have stuff out of Ohio, right?
Hold on, Mr. Romero, they're looking to see if there's priors in Ohio.
Well, my concern is frankly the representation that he's lived here his entire life, because one moment. You don't have anything out of Ohio? Your Honor, I am showing multiple arrests out of Ohio from 2012 for domestic violence. They were dropped. I'm not bringing it up for purposes of criminal background. It does appear, though, that there was a period of time that Mr. Shihade did spend in the state of Ohio. I'm seeing arrests between 2012 and 2013, so I'm only bringing that up based on the representation that he has lived his entire life in the area.
Okay, Mr. Romero, anything further?
Judge, my understanding, he's been here his whole life. There was 1 year in which I've been talking to Mr. Shihada, in which he and his wife went to reside in Ohio. I believe that was in around 2012 area. He's back here. Him and his wife are separated. He's paying as much child support as he can, and that's one of the bases as far as our request, Judge, as far as he doesn't think he's going to be able to, I mean, he's going to try and see if his family can come up with that bond money. But in the alternative, Judge, if you're inclined to place him on supervision, we'd ask that you ROR him and then place him on supervision, Judge.
Okay, does he reside at the 5670 address, Northwest 74th Place, number 105?
That's where he says he
Okay, I
lives,
just
Judge.
wanted to make sure. Okay, this is what the court's gonna do. On count one, the court is gonna set bond at $100. Count two, the court's gonna leave the convenience bond of $500 in place. Count three, the court's gonna leave the $1,000 in place. 4 and 5, I don't have to set a bond. The court is gonna do pretrial release, standard, but the court is gonna impose the additional conditions of a TAD monitor, no alcohol or intoxicants, and random drug and alcohol testing. Okay, thank you, sir. Good luck to you. Thank you. Okay, next one's gonna be Bruni Louise, and this is the one where the state
Mr. Bruni, come on up, please.
handed me the order of probation for aggravated stalking after injunction. Does that count too?
Yes, Your Honor.
Okay.
That's count one. Count two is the new offense before the court. At least on the booking sheet before me, I don't know what's on the findings.
Okay, so, sir, you're charged with, count one, probation violation or community control. And you're gonna be held no bond on that count. You also have violate count two, violate an injunction for stalking. You are going before your division judge, which is FI. They've signed a no bond order on February 8th, 2018 at 8:30 a.m., sir. Defense?
Judge would ask for a reasonable bond on count two in light of the fact he's being held no bond on count one.
Your Honor, in light of the circumstances before the court, and I will get into more detail, the state believes a reasonable bond is $50,000 pretrial release of the GPS monitor level one.
I'm
Your
sorry,
Honor,
what's the amount?
$50,000. Your Honor, I provided the court first with his order of probation from Judge McCarthy. Your Honor, Mr. Bruni was just placed on probation February 1st. The alleged victim in that case is the same victim as listed in this case, a police officer from a police officer, Your Honor. As you can see, some of the conditions that Judge McCarthy stated was he could transfer his probation to New York, and he was to immediately move to New York. 4 days later, he's still in Broward, Your Honor. And not only is he there, he's violating his other condition of probation, going right back to the victim's home. And the evidence against Mr. Bruni is strong. There's video evidence of him at that home. Your Honor, I also provided the court with the original arrest warrant and affidavit from the aggravated stalking case. Your Honor, providing details for the...
Provided a copy to Mr. Reedy?
Yes, I did, Your Honor.
Yes, he did, Your Honor.
And, Your Honor, I have great concern for the alleged victim in this case. If Mr. Bruni can be placed on 5 years probation, and within 5 days of being on probation, he goes right back to the victim's home. Additionally, Mr. Bruni's criminal history. 2014, obtaining controlled substance by fraud. He violated his probation in that case. 2009, grand theft, between $10,000 and $20,000. Possession of cocaine, 08. Possession of cocaine, 08. Grand theft, 07. Criminal mischief, 08. In 04, I'm sorry, 11 counts of grand theft, possession of cocaine, 05, carrying a concealed firearm and possession of cocaine, 03, and 2 DUIs, 1 in 98 and 1 in 95. Your Honor, I believe these release conditions are reasonable because I believe that they are necessary to help ensure and deter Mr. Bruni from continuing to have contact with the alleged victim. Also, and I apologize, Your Honor, also noting it's not just Judge McCarthy's order that he's not allowed to have contact with that victim. There's an injunction, order of protection, that another judge ordered Mr. Bruni not to have contact with the victim.
Judge, also,
Well, let me
$50,000
just,
on count.
hold on, Mr. Romero, because I have a question for Mr. Linder.
Yes, Your Honor.
So now this probation order that he's violating, he's supposed to move to New York.
Yes.
If I do a GPS, how's he gonna move?
Your Honor, and Judge, and the defense,
Unless he moves to New York, so suppose he says he's moving to New York and then comes
but,
back.
Your Honor, but here's my concern, hypothetically, because these cases aren't gonna be in front of the same judge at this point in time. If his probation is hypothetically revoked, then that condition isn't in place anymore.
I see.
Obviously, that can be dealt with at a later date, but to me, Your Honor, based on these allegations, it is a reasonable request, it's a necessary request at this point in time.
Okay, I'm sorry, Mr. Romero, go ahead.
Judge, right now, I just want to take into account, he's 54 years old. He's collecting disability $800 per month. He's homeless. There's no way he's gonna be able to post or know anybody that can post a $50,000 bond on count one. At this time, we'd have no objection as far as the free trial, but I'd ask you to set a reasonable bond as to count two, considering he's gonna be held no bond on count one, Judge.
Okay, is that it?
Yes, sir.
Okay. All right, the court is gonna find probable cause. The court does have grave concern. The court is reading the paperwork provided by the state. And the court, sir, you are to have no contact, direct or indirect, with the victim in the case with the initials of CL and his family members. Court is gonna put you on GPS level 1. And you are to maintain 1 mile from the victim CL's home and work address. And maintain a minimum of 1,000 feet from CL and his family members at all times. Okay, count 1 is no bond, and you're gonna see your division judge February 8th. As to count 2, the court is gonna set bond at $100,000. Thank you very much, sir. Good luck to you. Next one is Terrence Everett Mitchell.
He's approaching, Judge.
Okay, Mr. Mitchell. Good morning, sir. You're charged with 1 count of grand theft auto. Count 2, driving while license is suspended, third or subsequent offense. Count 3, grand theft auto. Count 4, possession of MDMA, ecstasy. Count 5 is possession of cannabis, 20 grams or less. And count 6 or 7, sir, you're gonna be held no bond. Pursuant to the warrants for your violations of probation. He also has a capias. He failed to appear before Judge Lynch for calendar call.
Yes, Your Honor.
And that is for the grand theft and the resisting. Is that for 6 and 7? Is that what 6 and 7 are?
Yes, sir. Yes, Judge.
Okay, all right. All right, sir, so counts 6 and 7, you're gonna be held no bond. Any objection to probable cause?
I don't know if there's another probable cause affidavit that I don't have.
There are two.
Are there? Because I only have one.
There's the second one from,
Okay. Give me one moment, please, Judge.
The driving while license is suspended as a citation.
no, he's referring, I don't believe Mr. Reedy has the lighthouse point.
I don't. Let me just take a moment to review this, Judge.
Sure, no problem.
No probable cause argument, Judge. Having reviewed the Lighthouse Point police report based on Mr. Mitchell's statements to the police, we do not have a probable cause argument at this time.
Okay, court's gonna find probable cause. All right, so counts 1 through 5. Any objection to the bonds in place?
Well, Judge, he's got a no bond hold. I don't know if Mr. Romero wants to add anything, but he's going to have to go in front of Judge Lynch on the no bond holds anyway.
Okay.
The only thing he's asking about inquiring is this second Grand Theft Auto, I believe count 3, and also while we're at it, count 1, when's the alleged date of incidents on count 1 and count 3?
Can you please repeat?
Well,
yourself,
count 1
sir?
is January 5th.
And count 3? The second Grand Theft Auto?
I believe that was yesterday.
Yesterday.
2-5.
Judge, nothing to add at this point.
Okay, so this is what the court's gonna do. The court's gonna find probable cause, if I haven't said that already. Count 1, the court's gonna set bond or keep it at 1,000. Count 2, 750. Count 3 and 4 are gonna remain at 1,000. Count 5 is 100, and counts 6 and 7 is gonna be no bond. Sir, you're to have no contact, to render direct or indirect, with the alleged victims in this case, who is Benjamin Barker, and the other person is Juan Guillermo Manrique Rueda, Rueda. Thank you very much, sir. Good luck to you. Good morning, Michelle. Okay, next one is going to be Robert Campbell.
And Your Honor, would the court be inclined to deal with Mr. Campbell and Mr. Perez at the same time? They're co-defendants. I'm going to be making release condition requests that are the same for both of them. It would just be, I guess, more time efficient than to make the same argument.
Sure,
Thank
as long
you.
as the defense has no objection.
Thank you.
Do you have any objection, Mr. Romero?
No, not as far as what the state wishes to share at this time for both of them.
Okay, Mr. Robert Campbell and Harry Perez.
Mr. Perez, come on up.
And, Your Honor, before the court makes any determination, if I could be heard with regards to the charges that are listed.
Okay,
Your Honor, man, I don't know where the error lies, but count 1 for both co-defendants, based on the arrest sheet, based on the probable cause affidavit and the allegations, the proper charge is trafficking cocaine, more than 400 grams, less than 150 kilograms.
so that's count 2.
No, the count 2 is conspiracy on each. Count 1 is the
Okay,
trafficking.
so trafficking cocaine, it should be 400 grams but less than 150 on count 1 on each person's case?
Yes, Judge.
Okay, so then I'll change that, so it's not, okay. Grams. Almost done, Madam Clerk. Huh?
And
Okay, Mr. Campbell and Mr. Perez, you're each charged with count one, trafficking in cocaine 400 grams, less than 150 kilograms. Count two is conspiracy to traffic cocaine, 400 grams, less than 150 kilograms. Any objection to probable cause?
Well, I don't know that there's enough here to establish a conspiracy. This is a pretty bare bones probable cause affidavit without a lot of details in it. For this type of a serious offense, I would expect to see more. The report indicates that Mr. Perez proceeded to inspect the cocaine. I don't know what that means. Was he looking at the cocaine? Was he staring at the cocaine? Did he touch the cocaine? We don't know what interaction he had with the cocaine other than this officer's very vague description that he proceeded to inspect it. Without more details, there's nothing to connect Mr. Perez to this transaction as a conspirator. And if there's no conspiracy with Mr. Perez, then there's no conspiracy with Mr. Campbell either, because the only person he could be left to conspire with is law enforcement. Something smells rotten in this probable cause affidavit, Judge. And I'd urge the court to take that into consideration and not find probable cause. If Mr. Perez had anything to do with this drug transaction, we would have read about it in this probable cause affidavit, and it's not here. I don't know how the officers can expect this court to make a finding of probable cause to conspire in trafficking of this amount of cocaine based on a sentence that says he proceeded to inspect it. And mere presence is not enough for a conspiracy. So I don't think there's a probable cause here to conspire for either of these defendants.
Your Honor, respectfully, I believe counsel is trying to make something out of nothing. I would ask the court, for probable cause purposes, to give the word inspect its plain meaning. Clearly, one cannot inspect something, or when it's referred to that someone is inspecting cocaine, I don't think there's any reason to imply that someone's inspecting it with their eyes. I think it's very clear in its face, Mr. Campbell's level of involvement, that he showed up with Mr. Perez.
We don't know that.
One moment.
We don't know how Mr. Perez got there. That's not in the probable cause affidavit either.
They're there together. They're there at the agreed upon location, because law enforcement showed up also to consummate the deal. The deal happened. Mr. Perez inspected the cocaine in the presence of Mr. Campbell. Mr. Campbell took the cocaine and, one moment, Your Honor. They left together because I'm looking at the place of arrest. They were arrested together.
It says here, Mr. Reedy, on February 5th, co-defendant Campbell stated that he had $46,000 towards the purchase of 2 kilograms of cocaine, and then defendant Perez proceeded to inspect the cocaine along with Campbell. So they were both doing that. And then it says co-defendant Campbell provided the buy money and and I'm paraphrasing, and took possession of the 2 kilograms while in the presence of defendant Perez. So the court is going to find probable cause as to counts 1 and 2 for Mr. Campbell and Mr. Perez.
Now,
so what about bond?
Your Honor, I checked this morning, and the standard bonds for the counts the court has found probable cause for, on counts 1 for each co-defendant, is $250,000. The reason for that is, if convicted of the top count, Mr. Campbell and Mr. Perez face a 15-year minimum mandatory prison sentence. I'm asking that the court keep the standard bonds in place, the total bond for each co-defendant $500,000. The reason being is I've got, one, I'm showing that both gentlemen live in the state of Connecticut. They have no ties with South Florida. They came here for the sole purpose of conducting a significant drug deal, 2 kilograms of cocaine. They had just under $46,000 in cash, and it's noted, Your Honor, in the paperwork I have attached to Mr. Perez's paperwork, I don't know if the court has it also, the notice of property seizure, where it notes that
46,000.
just under $46,000, an additional just over $1,100 in cash was found in the car. Your Honor, I would also note with respect to Mr. Perez, in 2003, in the state, this is all in the state of Connecticut, he was convicted of assault. 2001, breach of the peace. 1998, burglary. 1997, assault. Oh, I apologize. Before I go on to Mr. Campbell, Your Honor, the state is also going to be requesting that for both co-defendants, that a nebia requirement and
I'm
full,
gonna do a Nebia.
and we'd also ask that there be full collateralization be placed on each co-defendant, and that any property used for the collateral remain unencumbered during the pendency of the case, and we'd ask that these conditions be satisfied before they're assigned judges, before they're eligible for release from custody. With respect to Mr. Campbell's criminal history, it would appear, Your Honor, out of the state of Connecticut, that Mr. Campbell, I'm showing, is on probation for possession of a weapon in a motor vehicle. He was convicted on October 11th, 2017. He received a 5-year suspended prison sentence, 3 years probation.
You said you're not a convicted felon. What?
We can hear you.
Oh,
So I would also consider that to be an aggravating factor against Mr. Campbell, that it appears he's currently on felony probation out of the state of Connecticut.
So as far as Mr. Perez is concerned, the best the state can come up with is a prior conviction in 2003. There's scant evidence connecting him to these offenses. Mr. Campbell, according to this bare bones probable cause affidavit, is the one who had the money, got involved. Mr. Perez, there's no indication that they came down here together. That's an assumption the state is asking the court to make. There's no evidence to support the idea that they came down here solely to make some type of drug deal. That's an assumption that the state is asking the court to make. The evidence against Mr. Perez, I think, here is very scant. I refute the state's contention that you can only inspect something with your hands. I don't think that that's the meaning of the word inspect at all. If this officer wanted the court to make a finding of probable cause on this charge, he should have had a little more detail in his probable cause affidavit detailing exactly what it did that Mr. Perez did to inspect this cocaine. We don't know how far away from the cocaine he was. Was he on the other side of the room? Was he on the other side of the building? We have absolutely no details whatsoever to make a finding of probable cause.
And Your Honor, really logic and common sense dictates. We have two gentlemen here from the state of Connecticut, both from Hartford, Connecticut, that end up in Sunrise, Florida, in the same location at a drug deal, one of which is inspecting the cocaine, the other supplying the money and takes the cocaine. I don't think it is really requires a leap to say, yes, Your Honor, they came here together, Your Honor. It would be an illogical coincidence that they incidentally ended up here together out of the state of Connecticut at a drug deal at the same time.
The issue here is, what can the state establish? What's been proven on the four corners of this probable cause affidavit? And what Mr. Lender is saying is outside the four corners of this probable cause affidavit, unsupported by any evidence. What common sense might tell us, or what an assumption might tell us, so we can take a guess at what might have happened, that's not what we're here to do. We're here to determine whether there's probable cause based on the probable cause affidavit submitted to this court, not on assuming things or guessing at things or making hypotheses about things.
I believe we're past probable cause, but the addresses where they both reside at is part of the four corners.
Okay, anything further?
Mr. Romero may have something.
Yes, as far as the financial aspect is, as far as the bond, and regarding Mr. Campbell, as far as the standard bond, which is $15,000 on count one and $250,000 on count two, that's something that him nor his family is gonna be able to afford. What he does for a living is he does construction. Whenever he can get that type of work, he makes about $10 an hour. Sometimes when he doesn't get those sort of jobs, then he focuses on landscaping, and once again, the hourly rate's similar, about $10 an hour. He lives with his mother, been living with his mom for about 2 years now. She is a caretaker. Right now, where they live, their monthly rent is about $800 a month. They are on government assistance. Therefore, there's no way that him nor his mother are gonna be able to come up with the $15,000 on count one, let alone the $250,000 on count two. Judge, I'd ask you to consider reducing the bond on count one to $5,000 and reducing the bond from $250,000 to $20,000 on count two, Judge. Also, in reference to Mr. Campbell, I'd ask you to sign a photo order allowing us to photograph Mr. Campbell's injuries, Judge.
Okay.
Judge, I don't know if you want to go ahead and make a
And the
decision
court'll-
before I
the court'll-
proceed to go to Ms. Perez.
Okay, the court will, sign a photo order for you, Mr. Romero, so you could get me one, Mr. Reedy. No, go ahead, let me hear, argument. I would
In
like to
reference-
hear how long they've lived in the United States, in Connecticut. Give me a little background,
Mr. Campbell is a U.S. citizen, Judge.
okay?
He's living in Connecticut, specifically in Hartford, and that's where he resides with his mother. Like I said, they've been residing there for the past 2 years. Judge, and that's what the basis of my, the recommendation that I asked for as far as $5,000 on count one, $20,000 on count two. Now, in reference to Mr. Perez, Judge, he is a U.S. citizen. From what the state said, the last felony conviction he received was back in 1998. Judge, he's, at this time, he's unemployed. He was injured, and due to his injury, he's unable to work. He was working for Walmart. He was with them for about 5 years. At this time, he lived with his sister. And he lives with his sister in Hartford, Connecticut. His sister is the only person that's going to be able to help post his monetary bond. She works at a housing agency. She's a counselor. Her yearly income is about $25,000. And Judge, that is going to be the basis as far as why I'm asking for a bond reduction in reference to Mr. Perez. The bond, which is currently set at $40,000 on count one, I'm going to be asking that Your Honor reduce it to $4,000. And the bond on count two, I'm going to be asking to be reduced from $250,000 to $25,000.
And Your Honor, I apologize. I did also know, and Mr. Campbell in the state of Connecticut is also on 3 years probation for possession of controlled substance with intent to sell or deliver. He was placed on probation on the same date as the other offense. And lastly, I would just note, Your Honor, the representations of the resources that either Mr. Perez or Mr. Campbell have themselves or have through access to by other means through other people, it just doesn't add up based on the allegations that they were arrested or they had brought $46,000 in cash to a drug deal in South Florida.
Okay. Anything further from either side?
No, Your Honor.
Okay, this is what I'm gonna do. As to both gentlemen, I'm gonna say it again. Court does find probable cause for counts 1 and 2. The court is gonna do on a Nebbia hearing, and the gentlemen are to surrender their U.S. passports to the clerk and not apply for another passport. The court is gonna set bond on counts 1 and 2 for Mr. Campbell and Mr. Perez at $250,000 each, so that'll be a $500,000 bond. The court is going to require collateral for the bond shall be real estate and/or tangible personal property having a $250,000 net asset value of $250,000 on each count. And they can have a Nebbia hearing, obviously, before they're assigned division judge. Pardon? No. Here, I wrote it on there. Thank you very much, gentlemen. Good luck to you.
And, Your Honor, is it okay with the court if I provide, there's a lot I gotta put in these orders. Can I provide you with the orders for our afternoon docket to sign?
I'm sorry, I don't,
I've gotta prepare the NEBI and full collateralization
Sure.
orders for the court.
no problem.
Okay,
No problem.
thank you.
Okay, all right, then,
I apologize. If possible, can we recall, Raven Greer? Her mother has made contact with pre-trial and advised she would like to speak with you, if
Okay.
possible.
okay, where is the mother?
You'd have to call her. I have her phone
Tex-
number.
Richmond, Texas, I would
Yeah.
imagine.
Okay. All right, let's just do Dimitri Kolsky. Is he there?
I've been informed he bonded, Judge.
Okay, and then they want us to recall one. Who is that? Pardon?
Page 2, Raven Greer.
Do you have Raven Greer's, Madam Clerk?
She's in North Broward.
Hello,
Yes.
ma'am.
Hi.
Supposedly they spoke to your mom in Texas.
Okay. What about it? What did she say?
I do not know. I didn't speak to her. So,
Okay.
hold on a second. Madam Pretrial,
I'm
what did,
writing her number down for you.
okay, we're gonna call your mother on a speakerphone, okay?
I kind of don't want to, because, I mean, she has nothing to do with the situation. So I'm ready, like, to just hear, like, my hearing. And I'm kind of like, I'm ready to go. Because, like, literally, I was just grocery shopping, and I got harassed.
Oh, don't say anything else, Miss Greer. You don't want to talk to your mom, is that what you're saying?
Yes, sir.
She doesn't want to talk to her mom. She doesn't have to talk to her mom.
She doesn't have to, Your Honor, but it is relevant because she advised the court that I believe her mother is one of the people she would be relying upon to get court notices. So based on the court's order, her mother is involved in this
And
case.
she's on standard, I put her on standard pretrial release, ROR, so I would like to hear from her mother. She might have valuable input.
All right. You don't have to talk, Miss Greer, but you might have to listen.
Okay.
Yes, sir.
Hello?
Yes, Miss Shantae Campbell, please.
Yeah, this is she.
My name is Judge Kim Malika. I'm a judge in Fort Lauderdale, Florida. And we have your daughter here. She's actually appearing by video from the North Broward Detention Facility in Florida. And your daughter's being charged with count 1, resisting an officer or obstructing without violence. Count 2, obstruct by disguised person. And count 3, trespassing, occupied structure, or conveyance. Is there anything you'd like to add or tell the court?
Yes, ma'am. Yeah. Raven, okay, 2 weeks ago, Raven was in Mount Sinai. Okay, they kept her there for 7 days. Raven is mentally ill.
Okay, don't state what she's ill, because everything is being recorded and we actually have a live feed. So do you, so
You say
go,
don't say that?
well, don't say what the illness is, ma'am.
Oh, yeah, I'm not going to say what the illness is yet, but she, okay, so they released her from there. So Raven was arrested again, maybe like last Monday for walking on a turnpike. Some guy came and picked her up and said that it was her half brother. And I kept telling the police officer, that's not Raven's half brother. So a part of me be thinking, Raven nails is first done. She was reported missing back in December 9th. But they took the missing persons report off because we found her. I went to Miami to go get her, right? Raven tried to harm me. She tried to harm me. So that's how she ended up in Mount Sinai with, then. But the problem that I've been having is that they told me that they was going to petition the court to get Raven long-term mental help. But they never did that. They didn't take it to trial to get her long-term mental health. And it's like I'm here in Houston. It's like my hands are tied. It's I can't help my daughter. It's like I need the judge. She needs long-term mental help. Raven is going to kill herself, or somebody's going to kill her. She's not in her right mind. She's not in her right mind. And the guy that she supposedly met, she met him from Instagram. So she's meeting people offline and meeting up with these people. And like I say, I'm thinking that somebody is prostituting my daughter. That's what I'm starting to think.
All right, ma'am, let me ask you a question. Today, I should have told you from the beginning, today is just a determination of probable cause, and I determined probable cause on her charges of resisting, obstructing, and trespassing. And today we just consider what should happen with the case as far as her pretrial release, if there should be a bond set, if she should be transferred on her own recognizance. So I already ordered that I'm going to release her on her own recognizance. However, I did order that she's going to be put on standard pretrial release, which means she has to go check in when she gets out of a jail. She has to call in twice a week and report once a month. And if she doesn't do that, then her pretrial status will be revoked.
Your Honor, I'm also now, based on this new information.
Okay, let me just finish. I also ordered, ma'am, transfer this case to, and I signed paperwork to transfer it to the mental health court judge. I was advised by your daughter, Miss Greer, that you have an address, and I'm not going to say the whole address, but 215 Brazo in Richmond, Texas, for that we could mail the court notices there, or rather the clerk could mail the court notices there, and you would be able to get in contact with your daughter and advise her that a court date notice came. Is that correct?
But that's not going to be able to happen. Because Raven is, ma'am, I'm begging y'all. She cannot go back on the street. Raven needs to go into a mental hospital. This is her, ma'am.
I speak way more proper than you. I have a way more better mental health than you ever could do. My GPA was way more higher than you. You just sound really stupid trying to talk about me and try to call me mental when I'm way smarter than you. So you just need to stop, please, and leave me alone. That's why I'm getting a restraining order on you. But it's okay. You can keep going. It's all right. I'm sorry. I'll let her finish. Go ahead.
Okay. All right, so Mr.
Your Honor, based on the new information that's been provided, I'm requesting that the court reconsider the ROR to pretrial. Frankly, this is one of the reasons why Judge
Talking to the microphone, so
this is one of the reasons why Judge Lerner-Wren makes requests that cases that are transferred to her not be ROR'd. You've received testimony from her own mother that she's concerned for her safety if she is to be out on the street right now. I can also advise the court.
All right, thanks.
Judge Lerner-Wren is not in the habit of allowing defendants just to linger in the jail. There are situations where, certainly, especially when she deems necessary, that she will file the paperwork to have them brought to a taken out of the jail and brought to a hospital so they can begin receiving the treatment that I believe she needs. And I can contact, if it please the court, I can contact Judge Lerner-Wren's JA right now and let her know.
Excuse me, do you mind me asking what type of help do you think I need? Like, do you know me personally?
Raven, you need help, baby. Mama,
what kind of help? You keep saying I need help, but tell me what's wrong with me. Tell me what's wrong with me. Tell me.
Raven, you have been arrested 3 times.
No, I have not. I have never been arrested.
You was walking on the turnpike.
All right, I think that's enough of the family dispute. She's got a $100 bond. If what her mother says is true,
She doesn't have a $100 bond. I ROR'd her.
well, that's what the bond was before you ROR'd her. If she's, I mean, there's no guarantee that somebody isn't going to bond her out, and then she's out with no supervision.
Do what?
I'm American
$100
citizen.
bond
I'm
and
not a
Hold
minor.
on, ma'am.
$100 bond and pretrial. I'm just asking the court not to ROR her right out onto the street.
No, she can't be on the street.
Ma'am, please.
This is a free country. Like, I'm allowed
Okay,
to be
ma'am.
wherever I want to be. I'm sorry, not to you, Miss Kim.
Hang on, Miss Greer. Miss Greer, Miss Greer.
Because I'm not a minor. I'm not a minor, so you cannot tell me what to do. I do not need, like, supervision. I'm not a minor. I'm an adult in America. I can handle myself. So I'm tired of this.
Okay,
Like,
ma'am.
Raven, hang on a
Ma'am,
second, Raven.
Ma'am, just hold on a moment, because there's too many people talking. All right, so Mr. Linder, who is the prosecutor, what is, or he's from the prosecutor's office, not the prosecutor in this case. What is your position as to bond, pretrial release, GPS? What is gonna be your response?
Your Honor, I'm asking the court to set a $100 bond. Should the bond be
On
posted?
count one?
Yes. Pretrial release, should the bond be posted? Your Honor, I'd ask,
Thanks.
obviously, the court has already transferred this case to Judge Lerner Wren's division. As soon as we're done with this case, I'm going to be getting in contact with Judge Lerner Wren's judicial assistant, advising her of this case so it can be brought to Judge Lerner Wren's attention so she can take immediate appropriate action.
What are we doing with the mailing address now? It doesn't sound like, unless the mother can call her up, but it doesn't sound, the defendant saying she's gonna get a restraining order, so we need an address where, Ms. Greer can get her court notices.
Ms. Greer, do you have an address you can
Hold on,
provide us
ma'am.
with?
yes, I can also do, you can do 22155, Wildwood Park Road.
No, Raven, you don't even stay there anymore.
Yes, I do.
No, you don't.
That's another
My
Richmond
ex
address,
did
Your Honor.
Judge,
And I've
Okay,
done it
where is
already.
that, let me find out, where is that address and who lives there?
It's in Richmond.
Texas.
Judge,
Ma'am,
I'd
please.
ask Ms. Greer's mother to not interject herself into the conversation at this point.
In fairness, we have a mother that's very concerned about her child, so
And in fairness, we're trying to find out what
Okay,
address
hold on,
she's gonna be
folks.
staying
This is
at.
how this is gonna go. Ms. Campbell, I'd ask that, you just hold your thoughts. I'll ask you at the end, what your comments are, because there's just too many people talking, and I have to keep order with what's going on here. So, Mrs. Greer, you said that there's address 22155 Wildwood something. What is that address?
Wildwood Park Road.
And where is that? Houston?
It's Richmond. It's Richmond, Texas.
And what's the zip code?
77469.
And who lives there now that you can get mail there?
My ex-boyfriend. Like, we both have rented it together, but
He still lives
literally,
there?
yes. Like, he got a
No,
new
he
one.
don't. No, he do not. He do not live there.
Okay, ma'am, I'm
No, he
asking
don't.
you, Mrs. Campbell, you're gonna have to just wait and take notes or something. Okay, so. Anything else you'd like to say?
Well, she has an address where she says,
I'm talking to, her attorney here in
she
Florida.
has an address, Judge, where she can get mail, she can get notice. I just don't know what difference a $100 bond is gonna make in the grand scheme of things here. If somebody posted for her and she's out, then, she's out.
And then that means that there's someone that is, even $100 said, is making themselves responsible for her to a certain degree. And Your Honor, we've just received information that that her ex doesn't live at that address
But
anymore.
we don't know whether that's true or not. I mean, obviously, her mother has a motivation to discourage her from getting out, so, I mean, there's a motivation here for her to misrepresent things
Hold
to
on,
us.
Ms. Campbell.
And Your Honor, that
Okay,
mother's
this
only
is what I'm
motivation has been
doing,
her
folks.
well-being.
You don't know her mother. How
Hold
do you know?
on, no fighting. Listen, this is what we're doing. We are resetting this for this afternoon's docket. Mr. Linder, you are gonna call up, you said you're gonna try to get a hold of Judge Lerner Wren's division. I'm gonna hold on, or have the clerk hold on to this paperwork. Do I need to sign anything in the meantime that, she is not to be put on standard pretrial? Okay, this is what the court's gonna do temporarily. Until 1:30 PM, the court is putting a $10,000 bond in place,
We
okay?
object to that. That's a totally unreasonable bond, Judge. $10,000 on a misdemeanor? What's the court's justification for that? That you can do.
Okay, I'm gonna order a $10,000 bond is what I'm doing respectfully. I wanna get to the bottom of this. There's issues, there's concerns, and we'll address this at 1 o'clock, okay?
Excuse me, Miss Kim.
Yes, ma'am.
Miss Kim. Literally yesterday, I was just grocery shopping. I was doing grocery shopping.
Don't talk about the facts of the case, Ms. Greer.
I'm just trying to tell Miss Kim like what
Don't
happened.
talk
Like,
about the facts of the case.
Okay, so this is what we're gonna do. Ms. Campbell, Ms. Greer, we're gonna reset this for 1 o'clock today, okay? So,
Kim,
we'll
may
be
I-
1 or
back-
1:30.
Wait, Miss Kim.
1 or 1:30.
Talk now, Judge.
the hearing is actually over. We'll call you back at 1 o'clock, okay? Thank you, ma'am.
Thank you.
Okay, ma'am, we'll talk to you at 1 o'clock. Anything else we have to address?
Put him on his first possible.
Judge at Maine has,
Miss Kim.
I just wanna know what time we're starting again, the deputies.
1 o'clock. Okay? All right, thank you very much.
This afternoon.
Thank you.